Good afternoon, and welcome to the Appellate Division First Department. Most of you know our proceeding, and I will call the calendar, ask for the time that you need. Please ask for only the time that you need, not the time that you want in a rosy world. There are a lot of us here. We have 4.5 hours of argument time already requested. We are familiar with your cases, the briefs, and the record. And understand that the clock is for you, not for the court. So even if I only give you 5 minutes, but my colleagues want to ask more questions, I will not interfere with that, okay? All right. People versus Jose Marquez. Okay. 4, 1, and 4. Thank you. Morelli Law Firm versus Perez.
Good afternoon, Your Honor. Appellant requests 10 minutes to rebuttal.
Okay.
Good afternoon, 10 minutes.
Okay, 6 and 2 and 7. Newman versus Astral. Okay.
Harmon Max Leibowitz for respondent, 10 minutes, please.
Okay. 5 and 1 and 5. Pesquera versus 1968 Second Avenue.
Good afternoon. Appellants request 3 and 2.
Okay. Good afternoon. Do you have a cross appeal? Then you don't get rebuttal time. So how much time would you like? 3 minutes. 3, 2, and 3. People versus Isaiah Goodson is a submit. JDS Development and Parkside Construction.
Good afternoon, Your Honor. The appellant requests 5 and 2.
Okay.
Respondent, 2 minutes, Your Honor.
5 and 2 and 2. Employee Retirement versus Varvel. Okay. Okay. And are these all with you? Okay. 6 and 1 and 6. Rosenberg versus OSG.
Good afternoon, Your Honors. Morty Yankovich for the appellant. I request 7 minutes and 2 minutes for rebuttal.
Okay. Okay. 5 and 2 and 5. Basmanov versus Shiwacharan is a submit. Devlin versus AECOM.
Good afternoon, Your Honor. Appellant requests 8 and 3.
Okay.
Respondent, appellant CUNY and Stalco, requests 5 and 2.
Okay.
Respondent AIM requests 2.
Okay.
Respondent, appellant Gramercy Group requests 7 and 2.
Do you have a cross appeal?
Yes.
Okay. All right. So 5 and 2 to plaintiff, 5 and 2 to CUNY Stalco, 2 to AIM, and 3 and 1 to Gramercy. Interstate Indemnity versus East 77 owners. Okay. Do you wish to submit?
Yes.
Okay, submit. Have a seat until the end of the call of the calendar. People versus Taekwon Komiso, submit. And Williams versus MTA is submit. First case on the calendar. All those who are not staying for argument, you can leave now if you wish, okay? You may proceed.
Good afternoon, and may it please the court. Katie Roop, a law graduate with the Legal Aid Society, arguing on behalf of Mr. Jose Marquez pursuant to the practice order and under the supervision of attorney Now Try. Mr. Marquez's sentence of 3 to 6 years is excessive and should be reduced in the interest of justice to 2 to 4 years so that the parole board can review his readiness for release at an earlier time. Mr. Marquez is 56 years old and currently on lifetime parole supervision, meaning that he is serving a sentence with a maximum of life, regardless of this court's actions, and despite the 3 to 6 years imposed at sentencing. Given this maximum of life, as well as Mr. Marquez's nonviolent conduct, acceptance of responsibility, and struggle with substance addiction, his sentence is excessive and should be reduced so that he can demonstrate his transformation to the board at an earlier time.
Weren't all of those issues considered in reaching this agreed-upon sentence, seeing as in order to achieve a 3 to 6 sentence that was imposed here, the people had to dismiss the top count of Rob 1 because that would have made him a mandatory persistent violent felony offender. So why in light of that, would 3 to 6 on a reduced charge be considered excessive?
So Mr. Marquez's sentencing exposure, as you said, Your Honor, was under a sentencing as mandatory persistent, but the people chose not to pursue the robbery 1 charge and offered him the plea to 3rd-degree burglary.
But you're not suggesting that they decided not to pursue the robbery 1 charges because somehow they were weak. The burglary charge that your client pled guilty to was part and parcel of the res gestae of the case, right? So in other words, the basis for his conviction and for his plea was based on his robbing a store clerk at threat of a screwdriver.
The facts regarding the screwdriver are contested in this case, while the people...
There's video evidence here. Does the video show the actual robbery or burglary?
I have not seen the video evidence, but the people point to the video evidence as showing that Mr. Marquez used the screwdriver, but he stated in his interview with, in his pre-sentence interview, that the video shows that he did not use it to threaten the clerk, but instead she had picked it up and he put it
He has a
down.
parole interview scheduled for April of this year, doesn't he?
Correct, yes. So even though he has a parole interview scheduled in April, his earliest release date is not until August. And so if this court chose to reduce his sentence, his earliest release date could be earlier, which would be a significant difference in his life as I
So
stated.
counsel, back to the real question at hand. The mitigating factors presented in your brief were already considered by the trial court in the vein of having dismissed the top count, correct?
Some of those, yes, the factors would have been present and known by the trial court and by the people when they offered the plea, but just because this plea was a negotiated sentence does not mean that this court doesn't have power to recognize it as excessive. And as Judge Troutman noted in her concurring opinion in People v. Baugh, a negotiated sentence due to the power disparities in plea bargaining can still be an excessive sentence. And I think Mr. Marquez's sentence or case demonstrates this, since he had this possibility of the mandatory persistent. It makes sense that he would have agreed to a plea.
That and the video.
Depending on what the video actually shows. Yes, thank you, Your Honors.
Okay, thank you. You may proceed.
Good afternoon, may it please the court. David Gagne for the people. Given the defendant's extensive criminal history, he received a substantial benefit from his negotiated plea bargain. Defendant is a middle-aged man who has repeatedly committed robberies and burglaries, even while on parole supervision, as he was in this case. All told, this was defendant's 5th felony conviction and the 4th time that his parole had been revoked. Defendant committed this crime just 18 months after serving a 17-year sentence as a mandatory persistent violent felony offender. And defendant would have been sentenced yet again as a mandatory persistent if he had been convicted of the top charge, but he managed to secure a plea to the lower charge of 3rd-degree burglary, and as a result avoided being sentenced to a minimum of 20 to life. Under these circumstances, this was a very fair sentence, and this court should not disturb it. Unless there are any questions, I ask that you affirm.
Thank you. Counsel, you have 1 minute.
While Mr. Marquez has the criminal history that the state described, this criminal history is rooted in his struggle with substance abuse and substance addiction. This has marked his criminal history, and it marked the current offense, where he candidly and openly told police soon after his arrest, "Yes, that's me, I'm a drug addict." This statement serves to explain that his need for money that he talked about in the pre-sentence interview was related to his need to fund his addiction.
Well, in the pre-sentence report, didn't he say that he wasn't under the influence of drugs at the time of the incident?
Correct. He was not under the influence of drugs at the time of the incident. Instead, he stated to police that he was a drug addict as an explanation of why he needed money in this instance.
That's referenced in the pre-sentence report?
No, that specific explanation for his statement is not referenced in the pre-sentence report. His statement that he's a drug addict that he gave to police is elsewhere in the record.
At the time of his arrest.
At the time of his arrest, he gave that statement to police, correct. But Mr. Marquez recognizes the harm of his actions. He accepted responsibility to police, and by pleading guilty, and even with his sentence reduction, he will serve at least 2 years in prison and will remain incarcerated until the parole board determines he is ready for release. And so we ask this court to reduce his sentence in the interest of justice.
Thank you. On behalf of this court, we want to thank you for participating in today's arguments, both of you, and you did a good job.
Thank you.
Okay?
Thank you, Your Honors.
Have a good day. Morelli Law Firm versus Perez. Justice Friedman is recused on this case. Should there be a tie, the court will employ its vouching of a new judge as per our rules in the appellate division. Okay? All right.
May it please the court, Deborah Greenberger for Plaintiff Morelli Law Firm and third-party defendant Ben Morelli. After Mr. Morelli secured a landmark jury verdict for his client, he informed his client the appellate fee was 10%, a figure this court approved in—
Well, that was his offer.
Well, he indicated to the client that that was the amount for the fee. The client attempted—
That was the offer to continue the representation post-trial, because the retainer agreement that was entered into at the outset, and it should be noted that when your firm came in, there was already a liability finding in favor of the plaintiff. So you were coming in to do the damages trial.
He came in to do the damages trial and obtained a $102 million jury
Yes,
verdict.
I got that.
But
But
to
he's a
answer—
brain-injured defendant, plaintiff, so.
And I do also wanted to say to your question, though, Your Honor, that was his offer, and that offer was accepted
Where
through
was it
access.
accepted? Tell me where in the record the plaintiff accepts the 10% additional fee in view of the multiple emails rejecting that. Tell me where in the record I can find an unequivocal, okay, I accept your 10% fee. Tell me where.
So two things, Your Honor. One is what's in the record is that for 10 months, he did not object to the fee
So
at
is
all.
the
And I—
answer to my question that there is no place in the record that says specifically, yes, I accept your 10% fee? Am I right that there's no place in the record where the plaintiff specifically says, I accept your 10% additional fee?
Correct, Your Honor, but the case law is clear that you can accept through acquiescence, through conduct.
Isn't there also evidence in the record that he consistently rejected the 10%? Every time it was stated or offered to him, he said, I reject this, I'm willing to pay on an hourly rate, and let's work something out.
Respectfully, no, Your Honor. What the record is clear of is that's true until September, but then from September 2020 through July 2021, and this is in the counterclaim at paragraphs 141 to 145, a 10-month period during which the appeal was perfected and briefed and argued.
Counsel, that's all well and fine, okay? But in the face of, I reject, very explicitly he says, I reject your 10%, and then he counter-offers and says, but I would be willing to do an hourly rate. So tell me, from that email, where there is some equivocation. And don't say that, well, we continue to work on it, notwithstanding him saying no, and because we continue to work on it, we are therefore entitled. Tell me where he accepts your 10%.
So, Your Honor, if there's a concern about whether he accepted the 10%, that will be resolved in the underlying and pending declaratory judgment action, for which there's currently discovery going on. But that doesn't entitle Mr. Perez to bring a separate counterclaim for breach of contract, for which Mr. Perez is not just seeking the disputed fee, but also more than $2 million in interest.
Isn't it exactly the opposite of what you're seeking? He's saying, I want a breach of contract because you withheld money that I'm entitled to get, so why doesn't that state a breach of contract claim? I was entitled to pay by the hour. I was not required to pay a 10% contingency fee. You have not given me that money. I therefore have a claim for breach of contract for the return of that money.
2 reasons, Your Honor. First, there's never been a claim that where money is safely held in escrow, where the attorney has no access to it, where a court is going to resolve who's due to
He
it.
doesn't have it.
He doesn't have
He
it.
doesn't have it. So why, if he doesn't have it, doesn't he state a viable claim for breach of contract?
Counsel, we're
I
not
want
talking
the
about
money.
$100. We're talking about $5.5 million. And in this environment, you know how much money can be made on that money in investments?
And
So I'm sorry. The fact that it sits in an escrow account that I, as the plaintiff, have no access to doesn't help me.
But neither does it help Mr. Pirelli, who's bound by the ethical rules. And the other reason that there is no breach of contract.
You're asking to dismiss his claim. You're asking for the claim to be dismissed.
We're asking for the second reason the claim should be dismissed is that there's no contract that he could point to that has been breached. The underlying retainer agreement was limited to trial services. It was not for a
Right. I'm
But
glad
he
you
was supposed
said
to-
that, which means that the recovery from that trial that exceeds 33.13% minus expenses belongs to him.
I don't think I understand the question, Your Honor.
Okay, the question, I think.
Please.
Yeah. So the breach is that the original retainer provided for a third to go to plaintiff. By withholding the 10%, which is in excess of $5 million, that is the breach. And the underlying trial decision says the manner in which the money is being held does not impact on the breach of contract.
That's what the trial court said,
It's
but
not a defense. How is that a defense?
this court would be making new law to say that a attorney who's
Has any court said that a law firm that later is found to have improperly withheld monies from a settlement or judgment or whatever, that placing it in escrow somehow shields the attorney who withheld that money from liability for not giving the money when they were supposed to? What case anywhere in this state says that?
There's no case that's reached this, but there is a line of cases saying that when damages are premature or speculative, that a breach of
But
contract.
that's not this case.
Respectfully, Your
No, that's not this case, right? Because this isn't damages that are speculative or not. This is $5.5 million of his judgment that your firm put in an escrow account because that's what you wanted to be paid for appellate work.
Well, respectfully, Your Honor, even Mr. Perez admits that our client is entitled to quantum merit. So some portion of the 10% fee is
And
something.
he even said that, I'm willing to pay you by the hour.
But Mr. Morelli doesn't work by the hour, as is common among personal injury lawyers. I do just want, with my quick remaining time, to say the breach of fiduciary duty claim is also something that can't be sustained because the trial court just got it wrong. The trial court said that Morelli, quote, Morelli received an offer of settlement during trial, which he rejected, and nowhere in the counterclaims does it describe an offer of settlement during the trial. The Supreme Court just misread the pleadings.
There were offers, though, that your firm did not convey to the plaintiff, right?
There were allegedly 2 offers that there was a short delay, a short immaterial delay that were not conveyed. But
Oh, there
those-
was just a delay?
There was just a delay. There was no offer that was not conveyed.
I thought there was an offer that the firm rejected without telling the plaintiff about it first.
No, that's not.
That's not true?
That's not true, Your Honor. There was an allegation that before trial, there was a $30 million offer. The client rejected that in open court. That's paragraph 14 of the counterclaim. And there are allegations that there was offers for 47 and 51, which were shared with the client, along with the offer for 53, and ultimately.
So all offers, as far as your office is concerned, was shared with the client?
Absolutely, Your Honor.
All right, you'll have time on rebuttal.
Thank you, Your Honor.
You may proceed.
Good afternoon, Your Honors. May
Were all the offers shared with the
I'm sorry, I didn't
client?
hear
Were all of the offers shared with the client?
multiple offers were rejected before they were shared with the client. They were shared after they were rejected, as alleged in the
Let me ask a question
counterclaim.
about that, because, about the fiduciary duty in particular, because all the offers that were allegedly rejected before they were conveyed were clearly and undisputedly for amounts lower than what the case was actually settled for. So how can you have a viable claim based on those? Because what would the damages be if it was ultimately resolved for a higher amount?
Right, two things. One, we do have a basis to believe there were offers made prior to, or during trial, before the appeal, which would have been high enough.
And where do you state that in the complaint?
Those aren't expressly alleged, and the court found that our general allegations were sufficient to encompass those. We've said all along, if this court feels that we need to make more specific allegations, we're prepared to amend. We don't believe that's necessary because those are encompassed by the general allegations that there were damages as a result of offers not being shared with the client. But again, we're prepared to amend if that's necessary. We don't believe it's necessary, and the court didn't find it was necessary, but I do want to make that clear. Secondly, another,
Leave to replead?
sorry?
Did you request leave to replead?
No, because there was a motion.
Right, because you were successful.
We were successful. Secondly, though, there is another basis to find that these are sustainable claims, which is that fee forfeiture, even in the absence of specific direct damages, is another remedy for egregious misconduct, which is what occurred here. So that's just a separate independent basis on which the decision could also be affirmed, because we have alleged damages in the form of fee forfeiture as well. And so that goes to the breach of fiduciary claim. Going back to the breach of contract claim, what the appellants are asking this court to do here is to resolve material disputed facts in their favor on a motion to dismiss the counterclaims. The facts including, did Mr. Perez repeatedly and explicitly reject the 10% contingent fee for the appeal? Did Mr. Morelli repeatedly acknowledge that Mr. Perez rejected that fee and yet insisted on handling the appeal anyway, notwithstanding that the retainer agreement contains a provision under the extraordinary expense provision that says you cannot charge more than 1/3, in words and substance, you cannot charge more than 1/3 unless you have secured the client's consent in advance of those services. That didn't happen. That's clearly alleged in the counterclaims. There is no basis to dismiss these claims under the standard of a motion to dismiss. And on that basis, the underlying trial court's decision should be affirmed. With respect to this argument that placing the funds in escrow essentially has the effect of depriving the client of any substantive claim against the lawyer, that is such a radical and extreme interpretation of an ethics rule that is designed to protect the client and to ensure that the funds are available if and when those underlying substantive issues are resolved. It should not be ever used as a weapon against the client that it is designed to protect, as the appellants are trying to do here. So that argument should also be rejected. The appellants rely heavily on the precedent of Stewart versus NYC Transit Authority, but in that case, the client consented to the enhanced fee and supported the attorney's application for that fee to be awarded. Here, we have the opposite situation where the client has never consented and repeatedly rejected the enhanced fee. So Stewart does not apply. It's really irrelevant to this case. The appellants argue that Mr. Perez accepted the fee through acquiescence and silence. Their theory is that because he knew that Morelli wanted to charge him a 10% fee by allowing Morelli to handle the appeal and not firing the firm, he consented to that fee. But that is contradicted by all of the allegations in the complaint, and particularly the September 25th, 2020 conversation, which the appellants rely on heavily and which is addressed in paragraphs 129 through 139 of the counterclaims. In that conversation, Mr. Perez repeatedly rejects that the 10% fee, and the conversation essentially ends with Mr. Morelli saying, whether we agree or don't, I'm going to be working on Mark's behalf. Mr. Morelli is the one who acquiesced to the understanding that both parties had that there was no agreement as to 10%, and Mr. Morelli chose to handle the appeal on that basis.
That, because as I am reviewing the repeated offer of 10%, rejection of the 10%, the counter offer of hourly, because we're not talking about the damages portion of the trial, which as counsel said in a PI firm, is typically contingent. This is an appeal, which is a completely different wheel, right? In terms of our basic understanding of contract law and offer and acceptance, once an offer has been rejected and a counter offer has been put forth, and the other party acts on that counter offer by doing the work, are we not now operating under the counter offer of an hourly rate? And should this court not be absolutely focused more on a quantum merit basis of what the value of the work was for the appeal?
Well, there's certainly a fair argument that the Morelli firm accepted that counteroffer by doing the work, and also in addition, even in the absence of an agreement under the law, typically when there's no written contract, attorneys get quantum merit. Part of the problem here is that the Morelli firm hasn't asserted a claim to be compensated based on quantum merit.
But at the end of the day, that's where we end up. If this court rejects that the plaintiff accepted a 10% fee.
If they can prove their quantum merit. They stated they haven't maintained any records of their time and would be unable, and have never asked for quantum merit. So it remains to be seen whether they can establish that.
Okay.
Thank you, Your Honors.
You have 2 minutes.
Counsel, in your brief, you asserted a ratification argument. What's the difference between your claim that the offer was ratified versus that it was acquiesced to?
Substantively under these facts, it's the same. It's the 10 months of sitting back that's detailed in paragraphs 141 to 145, a decision to sit back and accept the work, knowing the terms. And to your question, Your Honor, there was never an open counteroffer. He suggested that the amount be hourly, that the scale be hourly. He never suggested an hourly rate. And Mr. Morelli immediately said that that was not a possibility. So there was never a possibility for an open.
So there was never an acceptance by anybody. Your firm just continued to do the work without an agreement on payment.
There was not an oral agreement, but there was agreement by conduct is our position. I do want to go back in my time to the breach of fiduciary duty.
Okay.
To your question, we don't believe there was any damages here. There is no allegation of any offer that was that exceeded the $55 million that this case was ultimately able to settle for, that Mr. Morelli obtained. There is no general allegation about, as my adversary stated, if you look at the actual allegations, which is the one that they have pointed to below, was paragraph 196, which is on page 80 of the record, and I would ask the court to look closely at that. That's at the end in the cause of action section, after she realleges and repleads all the foregoing specific allegations, which were about offers that had a delayed conveyance, not during the trial, as the court below said, but after the trial and after this appeal.
Okay. Would it make a difference whether the offers are during trial, after trial, post-appeal? What difference does it make? If after the court has issued a decision reducing the trial verdict And I would imagine saying, okay, you accept this number or go back to trial, and then the parties negotiate, well, what can we settle on, rather than going back to trial. I don't understand your point on that issue.
Sure. So, Your Honor, the theory of the trial court below was that even though there was no allegation that there was a settlement above the $55 million, that theoretically there could have been some harm because this 10% fee wouldn't have been necessary if they could have settled the case before the appeal. But there is no allegation supporting that they could have settled the case before the
Well,
appeal.
I think it's more general in the sense that since it's alleged that the firm received offers, rejected those offers, and didn't convey them to the client, that at that point there were offers that were rejected and not conveyed to the client, that the client might have taken the offer and would have eliminated the need for this appeal.
But the only offers that are actually alleged in the complaint are after the appellate work was done and after this appeal was decided. That's what's in the complaint. The general allegations that my adversary points to are not, when you read them in context, it's basically liberal pleading to the point of breaking. If you actually look at paragraph 196, it's at the very end in the cause of action section under breach of fiduciary duty. That's not actually an allegation, a general allegation. It's just referring back to the specific allegations in paragraph 159 to 165 that say that offers had a short delay in being conveyed after the appeal. So there's no harm from any allegedly delayed conveyed offers.
Okay,
Thank you very much, Your Honors.
have a good evening. Newman versus Ostral.
Good afternoon, Your Honors. Robert Roche for the appellant. Robert Newman as the executor of his mother's estate, Isabel Newman.
I just want to ask you something. On page 812 of this, of the record in the surrogate's decision, the surrogate states, under Jody's will, this account passed in equal shares to Robert Frederick and to her residuary estates. Is that accurate, that Jody left a will leaving these sums in equal shares to the three of them?
It was the will of the respondent's decedent, Jody Newman, that left the Robert and Rick, and as two brothers, two siblings of Jody, the residuary of the estate, effectively 1/3 each of the so-called Jody number 2 accounts.
So Jody's will left her estate in 3 equal shares, is that?
It left the account in question to herself and to Robert and to Rick, and that's part of our argument here. That's an admission against interest that we submit is an exception to the hearsay rule. The court very clearly in its decision ruled that there is no admissible evidence, and therefore both the constructive trust and the corollary fraud claim should be dismissed for lack of admissible evidence. We would disagree on a number of grounds, including but not limited to the will of Jody Newman. That's the respondent's decedent. Very clearly, that's an admission against interest. But that's not the only admission against interest in the record, and that's not the only reason that we're taking this appeal. It's one of a number of items of evidence that demonstrate that Jody Newman admitted.
Well, you seem to have hearsay problems with some of those admissions against interest, or putative admissions against interest, except it would seem for one of them, which is the notes contained at page A379 of the record, Leibowitz's notes, in which he says, dated October 23rd, 2009, I spoke to Jody and her mother, and then it goes on, he relates a conversation between himself, Jody, and his mother, and then says, she and mother both noted that this dollars, money, should go 1/3, 1/3, 1/3 to Jody and her 2 siblings.
Yes.
So that's the admission against interest for Jody, which does not seem to have a hearsay problem, because it's Jody's statement. But what is the statute of limitations on your claim? If it goes back to 2006 when the funds were transferred, then clearly you're out of court. You want to rely upon the fraud discovery rule, but there's some question whether that applies in the context of a constructive trust. Let's assume that it doesn't apply in a constructive trust. So what date becomes the accrual of the statute of limitations, which leaves you in court?
Well, there are two petitions. Petition number one is fraud. Fraud is, there's a discovery rule, the 2-year discovery rule under 213.8 that we rely on. That fraud was uncovered 1 month after Jody died. It was uncovered in June of 2017 by Rick Newman going through the papers of Jody Newman, uncovering monies that belonged to Mom.
Because it's a little bit hard to understand how the statute of limitations operates here, because in 2006, when the money is transferred to Jody, nothing has happened at that point which should raise any interest in any sort of challenge to it. I mean, perhaps Jody's doing exactly as she is alleged to have promised to her mother, according to Leibowitz's notes.
Correct.
So at what point is a claim made for this money?
Well, everybody thought and believed until the death of Jody that monies had been funneled in and were being retained in Jody number 2 account.
And there's no claim made for the money until that point, is that correct?
There could not have been a claim because everybody believed that Jody was, as she represented and admitted to her siblings, to May Suko, a
Counsel,
non-relative.
wasn't it readily discoverable well before the death of the decedent that the money was dwindling down? Because the bank statements were coming to the home of the decedent.
I don't open my wife's mail. This is Jody Newman living in an apartment that happened to be the apartment owned by Isabel. To suggest that Isabel should have been going through Jody's mail to know that.
I didn't suggest anything. I just asked whether, in fact, it was readily discoverable.
I don't think it was. And that was a question of fact at the very minimum. That cannot be tried on paper. And I think that's what the court did in this case. They tried things on paper. They determined things on paper that should have been determined at trial. If you don't believe Rick Newman, that he discovered in June of 2017 that there was a problem, the monies that have been transferred to the number 2 account didn't exist, well, that's a question of fact, but we would submit that that's not readily available. My sister, my brother, I don't go through their mail, whether they live with me or not, and that would be a violation of their right of privacy. But at the very minimum, there's another claim as well. The claim of constructive trust does not arise until that there's some dishonor. And that dishonor occurred when the respondent got appointed as executor of the estate of Jody. And he made it very clear that that money that Jody had promised to give 1/3, 1/3, 1/3 to the siblings, not going to happen. In fact, he's being sued separately in another suit for withholding the distribution of those monies that should have gone 1/3, 1/3, 1/3. In other words, the judge below found that the monies that were left, the residuary monies that were left in the 2 accounts after they were effectively emptied by Jody, even those monies that amounted to about $250,000, even those monies weren't distributed by the respondent's client. A further breach, but that's beyond the scope of this appeal.
Okay, you'll have time on rebuttal,
Thank you, Judge.
okay?
Good afternoon, Your Honors. I'm Herman Leibowitz, representing the respondent here. I want to clarify one thing that Your Honor had brought up. The will of Jody Newman has one paragraph that said that whatever was remaining in account number 2 at her death would be distributed 1/3, 1/3, 1/3. The residuary of her estate actually goes into trust for her son. So it's a specific bequest, which at the time of Jody's death was maybe about $260,000 that would be distributed among the brother Robert Newman, who's petitioner here, Frederick Newman, his brother,
So
and
this is your motion for summary judgment.
yes.
The burden of proof was upon you. How did you establish your prima facie case warranting dismissal of the petitions?
That there was no admissible evidence to carry forward the two petitions.
So why isn't what appears at page A379 of the record, your notes, why isn't that admissible evidence in which you write that Jody told you that this money is supposed to be divided among the three?
Well, first of all, she's deceased. There might be a question whether that is admissible, and it is not showing any kind of fraud, which is what the petitioner claimed here in both proceedings, either that there was a fraudulent
There's also a turnover.
transfer.
There's also a turnover petition.
Yes.
But doesn't this document in the record make you a witness in this case?
Well, I might be a witness, but I'm not a witness to any kind of fraud. In fact, the work notes and the conversation showed that there was a loving relationship between them.
That's a conclusion. I mean, the allegation is that there was fraud because this money, which was supposed to be divided among the three, was not. And this document supports the view, doesn't mean it's a final finding, but it supports the view that there was supposed to be a division among the three, and the claim is that it didn't happen.
We're not contesting that the paragraph of Jody's will that says that the balance in the account number 2 should be distributed 3 ways. As Mr. Rausch mentioned, that's a separate case before the court coming for a return
But
date.
anyhow, in terms of establishing your motion for summary judgment, it's your claim that you've met your prima facie case by saying that the petitioners don't have any proof.
That's correct. And we did show cases to that effect, that if there's no admissible evidence, a petition can't go forward.
So then the question becomes whether page A379 is admissible evidence.
My work product?
Jody's statement. Jody's admission against interest.
Well, Jody's admission was only that on her death, the specific bequest of what was left in account number 2 would be distributed, and we're not contesting that.
Counsel, I guess the issue in terms of what the fraud is the fraud about the money accruing and becoming, gaining interest on the $2 million, and in fact it didn't accrue but instead dwindle?
I'm sorry, Your Honor, I didn't understand the question.
So in terms of what the alleged fraud is here, is that account number 2 was supposed to have $2 million deposited into it, and that money was supposed to gain interest and accrue and get larger, but it didn't, right?
Well, the allegations of the petitioner, which we consider inadmissible because it's what a dead person supposedly told to family members, the allegation was that this money was being handled by Jody for her mother's benefit.
Right, but so the fraud isn't about whether in fact the money would be divided 3 ways in terms of what's in the petition.
The only money that would be divided 3 ways would be what's remaining in account number 2 in that paragraph of Jody's will. The rest of the money seems to have been used for the living expenses of the mother, Isabel, and her daughter, Jody, over the time that the money was in account number 2. And Jody's will said whatever's left in that account number 2 at her death would be distributed 3 ways, and we're not contesting that.
So nothing in your notes would establish any fraud, because what's in your notes just reflects that the money would be distributed, whatever is left would be distributed.
Exactly right, Your Honor.
Thank you.
Thank you very much.
You have 1 minute on rebuttal.
Just to be clear, that Mr. Leibowitz to my right was in fact the attorney of Jody Newman. So he is the agent. And the idea that he is unable to make an admission on behalf of his principal.
But he's saying, well, we gave you what we were supposed to give you. But what is the issue? I mean, the money that, we agree that the money that's in that account gets divided among the three, and there's no issue.
So we have an issue about the money was supposed to grow. As the money manager, it starts at $2 million,
But that's
ends at
not-
$200,000.
That's not in the attorney's notes. The attorney's notes doesn't have anything about the money growing.
Absolutely, you're right.
If we're relying on that as the admission, the only admission is that that money would be split three ways, and it was split three ways. So what's the admission against interest that you're relying
I
on?
think that there's an inference that when there's an admission to split three ways, it suggests, it infers that the money won't be gutted, which is exactly what happened over here.
That's not
There
in the
was
notes.
nothing left.
Nothing about that in the notes.
The judge, the other thing I could indicate that this is not the only piece of evidence that we're relying on. May Suko's affidavit is in the record. She's not a relative. There's no dead
This is the
man.
only thing about the attorney's notes that you're.
Oh, yes, Judge.
So
Yes,
the rest
once
of it
you
is
have-
other family members.
yes, yes.
So once you have non-hearsay evidence in opposing a motion for summary judgment, can you rely upon other evidence which is hearsay in opposing that motion?
I can, yes. I think the courts, no dispute, that the law of this case is as long as there's some admissible evidence, and there is, we submit.
What
you
is the
can-
admissible evidence here?
There's the affidavit of May Suko. She says that she spoke to and was led to believe by Jody.
She spoke to, right?
Yes, that's in the
Like
record.
hearsay.
That she heard Jody Newman, as did Rick, as did Robert, as did Stacy, all in the record. These
Now
are
we're doubling
conversations
up
that
on
they
the
heard
hearsay.
from Jody Newman. Those are admissions against interest. Those are exceptions to the hearsay prohibition. So the idea that there's no admissible evidence is, as a matter of evidentiary law, incorrect.
Thank you so much.
Thank you, judges.
No. I'm sorry, that violates the rules, and no. Okay, thank you. Have a good day, gentlemen. Pesquera versus 1968 Second Avenue.
Good afternoon, Your Honors.
Give me 1 second to put your time up. You may proceed.
Good afternoon. May it please the court, my name is Samantha Quinn. I represent the defendant appellants in this matter. My colleague has amply set forth her position in the briefs, and I will be very short in my comments. I want to point out that the court...
How do you satisfy the typical foundational evidence required for the admission of a videotape?
First of all, there was testimony from the defense witness that this was kept in the ordinary course of business, so that...
She wasn't even there on the day. She talked nothing about how the video is kept, where it's kept, nothing technical. She tells me nothing about whether she hadn't even reviewed it prior. She saw it just before going into the EBT. So it wasn't like she, at the store, took a look at the tape from the machine, saw that it's complete, nothing.
Your Honor, respectfully, she did view the tape a week before, and her testimony exactly comports with the plaintiff's description of events. And very, very significantly, if you look at the totality of the circumstance and the totality of the evidence in this case with reasonable inferences, there is no dispute that this videotape depicts what we say that it does. And in
Why
fact,
didn't you show it to the plaintiff? Why didn't you show plaintiff the video? How to authenticate it?
we sent the video to the plaintiff in July of 2019. He responded, I believe it was the 9th we sent it. He responded 3 weeks later and rejected it. And then at the deposition, he claimed he'd never seen it.
What do you mean responded that he rejected it?
It's in the record.
He wanted more of a tape before and after, correct?
I have the citation to the record.
Why didn't you provide it to the trial court in a form that the trial court could view it?
It was viewable by everybody who was looking at it. We thought we could. And if they had-
We had to jump through hoops to see it, okay? So this was not an easily viewable submission. And so if the court can't see it,
Well, respectfully, Your Honor, the court never told us that they couldn't see it. The motion was pending for almost a year. We would have endeavored to provide a different version, a different format. But what I do want to bring up, I see my time is running low. We've had 2 camp conferences in this matter before Tamar Finkelstein, who is a special master. And at both of those conferences, counsel for the plaintiff represented that he would stipulate to this video. Not once in any of the underlying papers or the appeal or in those 2 appellate division conferences was there any question as to the accuracy of what is depicted in the video.
Did you make a motion to renew or re-argue with providing the authentication, which the court said was lacking? And if not, why didn't you make a motion to renew as opposed to appealing the decision?
Your Honor,
Especially when the judge says, we couldn't see the video.
I'm not sure why that was not done procedurally, but what I'm telling the court now is that if you view the entirety of the record, the totality of the circumstances, it's very clear that this is important dispositive evidence that should have been considered, and it is dispositive of the events in this case. Thank you.
Even if a piece of evidence is, as you say, dispositive, does it mean we can just throw away the foundational requirements for admission of a piece of evidence?
Not saying that we didn't meet the
And
foundation.
so my first question to you was, how did you satisfy the typical foundational requirements for the admission of a video? Because you want us to say that on the basis of a video that the plaintiff had not seen, that the court had not seen, that it is self-authenticating, basically.
That's not my argument, and respectfully, the plaintiff was provided this video in 2019. There's no evidence that the plaintiff hadn't seen this video at the time the summary judgment motions were made, and certainly—
I'm talking about at the time of the EBT, the plaintiff had not seen the video.
But it was provided to him 3 years prior, and he objected to it in writing 3 weeks after he got it. So the fact that he didn't watch it for the next 2.5 years, that is respectfully the plaintiff's issue,
Well,
not the
in terms of
defendant's.
authenticating it, why not show it to the plaintiff
Exactly.
at the EBT and have the plaintiff point out herself on the video?
Because then we wouldn't be giving you all these questions. If the plaintiff at your EBT had been shown the video and said, "Is that you?" And she says, "Yeah, that's me, but I don't know what happened before." But now we've got it locked in. It's her.
But is there any dispute that that person on
You
that
don't
video
get
is
to
her?
ask us the question. Unfortunately for you, but I get your point, counsel. You'll have time on rebuttal. Counsel?
Thank you, Judge. Michael Kremens, good afternoon. For the respondent, Pescara.
Why didn't you show your client the video?
We didn't show the client the video. We made a strategy decision not to show the video. We didn't believe that this.
I mean, you can make a strategy decision that you're going to oppose its admission, but you don't show your client the video?
We did not feel like we had complete discovery. We rejected it because it was not in accordance with the CPLR. We got just the video itself. We did not get the outtakes and all of the other requirements as per the CPLR. We rejected it. There was a prior.
Are you claiming in some way that this video is inauthentic or somehow is
altered or
spliced together,
doctored? Yeah.
altered, yes?
Well, you know, we have no idea. The video was never authenticated. The only authentication.
That doesn't stop you from taking what you received, taking it to a video expert, and say, tell me, is this, has this been altered in any way? They would be able to tell you that.
But, Your Honor, I don't think that's our burden. The burden on summary judgment is for the move-in.
But where's this case going? If ultimately that video, which we've watched, gets shown at trial, where is this case going?
Well,
I mean, the video shows what it shows, so even if you're successful on this appeal, where are you going in the case? Because the video ultimately is going to be seen by a jury.
All they have to do is put your client on the stand, show her the video, and have her ID herself.
Well,
And then the video comes in.
It's going to end up authenticated.
whether it's authenticated or not, that's a trial. It's a different burden, and that's something instead. I'd rather not give my trial strategy out at this point. But
okay.
But seriously, it's a different burden. Here, the movement has the appellant has the burden here, and I think Judge Taylor was 100% correct. Instead of asking, give me a better copy or give me more information or.
But as
whatever it
counsel
was.
said, they were never apprised. They were never apprised by the court that they couldn't view it. Had the court, all it takes is an email or a phone
Judge
call
Taylor
by
s-
a court. Counsel, let me finish talking, please. A comment, a call, some kind of communication from counsel's office could have remedied that problem.
Judge Taylor specifically states that in her decision, that she didn't need to do that in order to make her decision and find, in fact, that it was not properly authenticated. And
Well, how do you make that determination without examining the video? I mean, maybe it's supported by other aspects of the evidence in the case.
Well,
Maybe it's supported by a still photograph which shows that what's in the video is accurate.
Well,
And just to add to my question to you, I mean, I'm not giving you a chance to answer the one I just asked you, but you're just saying, well, if you submitted a pivotal piece of evidence to the court and it turns out the court wasn't able to examine it, I'm sure that you would hope that someone from the court would let you know, hey, there's a problem with that piece of evidence, where you have no reason to believe that there is a problem with that.
again, Judge Taylor specifically stated that, and specifically stated that when you looked at the totality, as they say, the totality of circumstances, they produced a witness that was not there, that saw the video some almost 6 years later, the week before the deposition. There were 15 employees in this small bodega. This was not a ShopRite.
But counsel, is there any dispute that the person in the video was your client? Is there any way to dispute that the person at the video is your
Or anything in the record to assert that the video is inaccurate? Anything at all?
Yeah, there is. The defendant witness, excuse me,
Bergerano.
thank you, stated in her deposition that when she saw it a week before, that she didn't see any ice on the floor, that she didn't see any water on the floor, that she didn't even know who that person was. I mean, that in itself, I think, is a triable issue of fact. The burden doesn't switch.
We saw the video, and I could see the ice.
Well, so
And I
could
could see the ice melting.
The
Okay.
defense witness
You can
couldn't.
see the ice falling.
The defense witness couldn't, and that's the only testimony. It doesn't shift to the plaintiff. I don't see why it's our obligation, our burden.
So we should disbelieve what we see.
I'm not saying. I just say that they have not established their prima facie entitlement to summary judgment. It doesn't switch to the plaintiff. I don't believe we need to say anything in terms of response.
Before you finish, I just want to make sure that I heard you correct, which is that the witness indicated that she did not see any ice or water in the video?
That's correct.
Okay. And that's in the record, right?
That's in the record.
Okay.
Okay, thank you. You have 2 minutes, counsel.
I'm not finding the testimony in the record regarding that the witness didn't see ice, but it's very clear that the video depicts ice, a bag of ice being dropped by a customer and falling on the floor, and about.
But if your witness indeed, and I'm going to have to go back to the EBT transcript now, because I don't recall what he just said, but if your witness says that she viewed this video and doesn't see ice or water on the floor, isn't that problematic? Because we saw it. So how does she see that video and not see that? Was she shown the right video?
I don't believe that's what her testimony says. But if I could just address another point, I will see if I can find that and I can show you. I can advise the court. The whole point of authentication is to make sure that the video depicts what it is purported to depict, and not once in the underlying papers, in the mediations, or in the appellate briefs has the plaintiff ever taken the position that this video doesn't show exactly what we say it shows, which is a customer dropping ice, ice melting, creating a hazard, and less than 10 minutes later, his client comes and falls.
Can we agree that it's not just the few minutes just before the fall, right? So that it seems to me that I wanted to see the video to make sure that there were no employees of the store within the aisles or within hearing range of hearing that bag of ice fall to this hardwood floor, right? So I wanted to see the video to see, was there anyone who was an employee of this store who would have been put on notice that something has happened and let's get that cleaned up, right? And so it's not just the happening of the fall that is relevant, but it's the circumstances before the fall, right?
Yes, and there's an hour of footage before the fall, and in the video, 13 minutes before the bag of ice is dropped, there's an employee who's doing a spot cleaning of the floor. 9 minutes before the bag
Well, I don't
of
see
ice-
him spot cleaning the floor. I see him
wiping something with a towel. And that's at video 3728 to 3848. 9 minutes before the fall, the dropping of the ice, there's an employee stocking
right.
the refrigerators. 2 minutes before the ice is dropped, and 12 minutes before the accident, there's a third employee who walked up and down the aisle. There were employees prior to that time. And I'd say my time is running out, but I do believe that the video is the best evidence of what happened in this case. It should
And
have
there
been
is a still
considered,
photograph which is authenticated, correct?
which doesn't disagree with the video.
Which is consistent with what the video shows.
Exactly. As is the testimony of the plaintiff is entirely consistent with the video.
Right, but the still photographs are after the accident.
Yes.
They're of her on the floor, right?
Yes.
Yeah. Okay, thank you. All right. JDS Development versus Parkside Construction. You may proceed.
Thank you, Your Honors, and good afternoon. Andrew Bourne from Cohn, Ziffer, Frenchman, and McKenna on behalf of the plaintiff appellant JDS Construction Group. There are several issues on appeal. Today, I'm going to begin by talking about what we think is the first error of the Supreme Court, which is its application of the default and termination procedures in the performance bond to a claim for delay damages. As set forth in our brief extensively, the default and termination procedures in the performance bond do not apply to a claim for delay damages. That's what this court found in 1199 Housing Corp.
So it's a little bit hard. I understand there is some support for your position in that case, and I guess maybe it's the best you have, so you run with it. But in terms of what we said, it's true we uphold the delay damages cause of action, but it's not like we said a whole lot about it. I mean, it's not like we discussed the issue in terms of the fact that the performance bond says A, B, and C, and we say, well, delay damages falls outside of that.
You're right, Your Honor. The opinion itself is quite terse in this area. But what the important part about that opinion is that it affirmed the trial court's opinion, where it did make these distinctions and the discussions that
The
were.
only thing that case talked about was a pleading standard, and what's the pleading standard to allege, and that's not an issue in this case. But let me ask you a question. Why wasn't the default in this case, when the time came for the work to be done back in 2016, and the work wasn't completed? Why wasn't the owner then obligated to contact the surety and say, hey, the time has come for the work to be completed, the work hasn't been completed, we think that we want to give them extra time, even though they have defaulted and not completing the work under it, but we want to notify you, have a conference to discuss it. Why wasn't that required to be done?
Respectfully, that was not required to be done because that's not what was required under the construction contract or the performance bond. The construction contract, and I'm talking about Section 25E, permitted the owner to proceed with the contractor who was acting with a delay, and then seek delay damages from that contractor.
In that circumstance where here, there's no notification given, the delay happened, the delay was a year, they paid them for the work, everything was completed, another 8 months went by, and then they finally notified them of a default. Under those circumstances, you're saying the surety has no right whatsoever to try to make things better or correct things or take some affirmative action on its own. It's just obligated to stand there and wait till whatever time the owner decides to declare a default, and they say, okay, I'll pay up, even though I was never consulted, I never had a chance to bring in my own contractor or to make sure the work happened earlier?
Well, and what we set forth in our briefing, what the cases talk about, there's two different types of damages. There's the default damages, right? And cases, I think the cases that they cite primarily, if exclusively deal with default damages, which is the costs incurred for fixing or hiring a new contractor to fix that. And all those cases.
But that's not to say you have to comply with the notice provisions, whether or not they have to do with delay or they have to do with something else. There's clearly case law from the First Department, which is what the trial court relied on, saying you have to pay up. If you don't comply with the notice provisions in a contract, you can't rely on that bond and recover under that bond.
Respectfully,
Go ahead.
150, I think you're referring to the 153 Hudson case. That case is exactly what I'm talking about, which is they're talking primarily about default damages there. The contractor, the owner in that case actually, was seeking recovery for the cost to fix the work. If you go back, the complaints are available online on Westlaw. The costs for, the increased costs, those are the default damages, which I can see.
So you're saying damages that result from delay, even if the delayed work is done correctly, there's no recourse for that?
Well, there is a recourse under the performance bond because as this court, as we submit, held in 1199 Housing Corp., the conditions precedent in the performance bond do not apply to a claim for delay
You're
damages.
saying the surety has no rights whatsoever. If no matter how long the delay is, no matter what the owner does, the surety never has any rights to come in and say, hey, I want to fix things. Hey, I want to bring in someone new. Hey, I don't want to wait. I don't think it's appropriate to wait 3 years and then come in. There's no way to protect itself. If it's delay, period, and the surety has no rights.
Right, and that's precisely, well,
What case holds that?
what case held that? 1199 holds that.
The trial court held it, but what case from the First Department holds that?
1199 was affirmed. If I could just.
But
I
not
see my
that
Go ahead,
time's up.
keep on. If I don't stop you,
Okay,
you keep
just-
going.
1199 was affirmed, and it was extensively briefed. This issue was extensively briefed, whether as a matter of law. It's actually in our record. It's at Appendix A3740 to 44 and A3787 to 800. It was extensively briefed whether, as a matter of New York law, these conditions precedent apply to claims for delay damage.
There's nothing in the First Department decision which says anything about that. I mean, I've read that backwards and forwards. There's nothing from the First Department which actually addresses this issue head on.
Help me to understand then, what are because the surety bond does have requirements for notice, right?
Yes.
And so notice of what?
Notice
What is it that you have to give notice of under the surety bond?
when you are going to declare a contractor default, you have to provide notice under the
So
surety bond.
that's what 3.1 says, that if you're contemplating declaring a default, you have to give notice, and there's got to be a conference, and there are all the procedures. So is that your position here? Is that your ultimate position here, that, look, we never plan to declare a default because, first of all, we want this job to go on. They were supposed to get to the 86th floor, and we didn't want them off the job. So we tolerated the delay, and you're saying that doesn't fall within the context of default in 3.1. Is that your position?
My position is that we did not have to notify them until we were going to declare a default, which we did when they stopped showing up, when
Yeah, right before they got indicted.
When they got indicted, they stopped
you
showing
wait
up.
until they're about to get indicted to declare default. They've been 382 days late.
And why are there provisions about a conference? Well, if you could wait till the very end and everything's done and everything's completed, why would there be any language about after you decide or contemplating a default, then you have to have a conference to discuss it? What would be the purpose of that if you could wait till everything's done, it's a year and 8 months later, and then, hey, we're notifying you. It all happened a year and 8 months ago, but we're notifying you now, we're declaring a default. Why would it discuss conferences then?
for the exact purpose of what all those cases where they're all rejected about the conditions precedent is that it has to do with self-help by the owner, going out hiring new contractors. You do want to keep the surety involved, but the flip side to the question, and I'll answer it, is what do you do about delays? Are you supposed to give a notice every time there's, under their theory, every time there's 1 day of delay?
No,
Fair
I don't.
point.
You have to
Fair point, fair point, but the other side of that is how is the surety protected that you just keep quiet, like in this case, for 382 days or something, and then you wake up and say, oh, you know, you're in under bond because of the delay. What's the rule going to be?
But the rule is precisely what was set out in 1199.
They're stuck with your declaration. So no court, there is nobody outside of the developer that decides when an appropriate default should be declared. They're stuck with your decision to wait a year. They were supposed to put the first 36 floors by a date certain. They didn't get those first 36 floors up for a year, right?
Correct, yes.
So the surety company has to pay if they mess up, but you don't have to tell them that they've messed up for a year?
They have to pay the delay damages. If the conditions precedent.
So you don't have to tell them about the delay damages for a year plus 8 months after that, but they have to pay for them.
Well, yes, Your Honor, they do. And the reason why is.
It could be 5 years too, by what you're saying.
I suppose it could be 5 years.
You don't like that.
But
yeah, that made him uncomfortable.
it's a little hot under the collar here, Your Honor. No, you're right. It could be 5 years. But the issue is, this is what they agreed to. They signed on to, and they're bound by the construction contract as well. They're jointly, they are joint obligees under that construction contract. That's what they agreed.
Why isn't it, okay, it says if there's a default, they have to be notified. Once they haven't completed the work in the time allotted, there was a date by which they had to complete the work. Once that day happened and they didn't complete the work, why isn't that a default for which they have to be notified for under the terms of the surety bond?
Because it's the option of the.
And does the writing, does the writing say we have to notify you when we declare a default or when there is a default? Because those are two different things, right? As far as I'm concerned, the moment they missed that deadline, they were in default. So does the language say declare, we declare a default? We have to give you notice? Or if the contractor is in default?
It's actually, I'm going to refer to 198 of the record. It's paragraph 3. This is the performance bond, paragraph 3.1. It says the owner has to alert the surety that it's considering declaring a default, a contractor default. It does not say.
Okay.
It just says considering to declare a contract default, which is different.
All right.
I see my time's up. If the court has no further question, I'll reserve.
We'll get you on rebuttal.
I'm sure. Thank you.
All right, you're up.
Thank you, Judge.
And you only gave yourself 2 minutes?
I did.
I'm going to give you more because, trust me, we're going to have more
I appreciate the
questions.
warning. May it please the court, Adam Friedman for the respondent.
Let me ask you about this particular provision in the contract, which says, the owner has notified, the surety's obligation shall arise after the owner has notified the contractor and the surety that the owner is considering declaring a contract a default and has requested and attempted to arrange a conference. Doesn't that language say that you're only entitled to notice if they are considering declaring a default? So what's wrong with the argument that, hey, we weren't considering declaring a default, we let them finish the work and you're responsible, and nothing about this contract requires notice under those circumstances?
So we're talking about two different things. There's, in the bond, Section 3 has paragraph 3.1 and 3.2 and 3.3. I mentioned 3.3 because they're all conditions preceding to the surety's obligation under the bond. Paragraph 3.1, Judge, is exactly what you described. Then there's paragraph 3.2, which is another condition preceding, which is when the contractor is in default and has been declared to be in default.
A declaration of a default.
Right.
And that doesn't happen till way after the work is done.
Here it did, right.
So what's the one you're relying on?
Relying
And
on-
formally terminated the contract, which is the last thing that JDS wanted to
What's
do
the
here.
one you're relying on? If you're not relying on one, what are you relying on?
Well, we're relying on all of them.
So what's the specific one which language supports you that they are entitled to notify you before they've officially declared a default?
They're required to notify us twice. The first is when they are considering declaring a default. The second time is when they have declared a default. The problem in this case is that the default that they are claiming happened within the scope of the bond, which covers the work from the cellar to the 36th floor, happened after the principal, Parkside, completed the 36th floor without any issues in his construction work, without a default, and not until he was working and paid in
Was
full.
the
argument they
35
can't-
floors completed within the time frame that they were supposed to be completed?
No, absolutely not. He was a year late, but we know nothing
What's
about
your
that.
argument that they can't declare a default after all the work is already all completed and they've been allowed, that's too late at that point to declare a
That's the
default?
law in the state, that there's
So none of
there's
this even
substantial
comes
completion
into
doctrine.
play because it was just too late. This is your position, because it's too late for them to declare a default at that point.
Yes, yes, but let me be clear.
But that's
bu-
not your position when the claim first comes in. When the claim first comes in, the exchange of emails and letters between you and JDS, your claim isn't, you're too late, you never gave us notice, you're asking for information, what's been done, what hasn't been done. You don't say, you don't have a claim against us, you never told us about this.
We don't know. That's the point. We don't have any idea. The surety has nothing to do with the construction. So they make a claim. Parkside, who had wound up being indicted, says, well, I don't know what this claim is. I'm not in default. And he gets indicted. So we say to them, well, your claim's disputed. Parkside says they didn't do anything wrong. And we ask for all kinds of information to try and do an investigation like any surety or insurance company would. And they refuse to respond. They just sue us. So we, at the time, Judge, we don't know what the story is. We're trying to get the information, which we eventually get during the course of the litigation and from talking to Parkside. One other thing I wanted to mention.
But at that time, and that's in September of 2018 when this claim is getting started, you never intimate that the problem is that the claim was untimely. There's no indication that the claim is untimely in any way.
We don't know that the claim is untimely when they make the demand. And they refuse to provide the
You're a
information.
party to the contract, so you know when this work is supposed to be done. So when you get a claim after the time period, doesn't that open a switch and say, well, how could this be? I mean, this is after the time the work was supposed to be finished. Now they're telling us?
No. There's two problems with that. One is we are not a party to the contract. We're the surety on the bond. And number two is, in the bond, and in many bond forms, the surety waives notice of extensions of time because in construction there frequently are delays. And if we had to approve...
I'm not saying that you're a party in the legal sense, but you know what that contract is all about. That's furnished to you.
Yes.
But you're saying the sureties don't typically keep track of the construction projects under their insurance, under their policies throughout the company.
Correct. Some sureties may send annual status request forms, but that's the extent of it. And you know that there are going to be extensions of time, and unless they are material extensions, which is a difficult thing to prove under the law, there are...
So the work was supposed to be completed in October of 2016. The work with the 35 floors or 36 floors was supposed to be completed in 2016. You get a claim in 2018. Doesn't that seem odd to you 2 years afterwards?
I can't...
Wouldn't your initial reaction to that be, this couldn't possibly be timely?
I would tell you that my initial reaction was that this is odd, but my initial reaction was not, this is absolutely untimely, we need to not deny the claim, and I think that would be a breach of the obligation of good faith that the surety owes to the obligee. We have to do an
You don't
investigation.
even mention the time aspect in your correspondence when this claim comes in 2 years after the work was supposed to be finished.
Correct. We have no basis to acknowledge the time. We have to
Even
investigate.
though
We have
you
to
knew it
requ-
was supposed to be finished 2 years before.
I'm sorry, Your Honor. I didn't mean to interrupt you. Did we know? We know that the original time, the amount of time it should have taken to complete the bonded scope of work. We do know that, but especially on projects like this, there are delays. There are delays because your principal is at fault. There are delays because others are at default. It's not unusual that you have a delay on a job of years, let alone a year. So I don't think any of us looked at it like, oh my God, this is so unusual. We need to deny this claim immediately. I understand my time is up. I wanted to note for Your Honors that after we filed our responding brief and before they filed their reply brief, this court issued a decision in a case called Prismatic against International Fidelity. 2022-01346 is the case number, exactly on this issue, exactly upon the.
What's the site?
I'm sorry. It's Prismatic against International Fidelity on exactly the issue of the application of the conditions precedent in the A312 performance bond to a post-completion claim for indemnification.
What's the citation again?
Well, the case number is 2022-01346, and this court said, reiterating.
Citation? I'm sorry, that's not a citation.
No.
Probably a Westlaw citation here.
That's just the
I know.
It sounds
No,
like
I
the
know.
appeal.
I'll submit a post-argument letter if that's all right.
Before you go, and I know we've been over this, but I just want to
Of course.
see if I can clarify it a little bit more for myself. So when you get to 3.1, the owner has notified the contractor and the surety at its address described below that the owner is considering declaring a contracted default. If they're not considering declaring a contracted default, what's supposed to happen? Because, look, we don't want to declare default. We declare default, they're off the job and we'll be nowhere. But how does that fit in with the delay when you're not declaring a default, but you're holding it, you're accepting this late performance, but you know that you think you have a claim for that?
I completely understand the question. So the obligee, in this case JDS, has two options. They can decide that we don't want to deal with the surety process and terminating and defaulting our contractor, or they can seek a remedy under the bond. If they don't want to deal with the surety and they want to keep the contractor on the job and they want to waive the default and allow him to continue to perform and reserve their claim for damages, they are free to do that. But then they've released us. They discharge us under the bond. If they want to make a claim or preserve their rights under the bond, then they have to satisfy the bond's conditions precedent. Paragraph 3.1 says they have to give us notice that they are considering declaring Parkside to be in default. Give us an opportunity to have a meeting, because this is all about the surety being able to mitigate its loss, control its loss. So we have a meeting where we see maybe we can avoid a default declaration, maybe there's something we can do, maybe the Parkside needs money and the surety can infuse some money and get them to complete. Then you get to paragraph 3.2, they have to declare a default and give us notice that they've done so. And then paragraph 3.3, which they never did at all, is they simply have to say, we will pay you whatever the remaining contract balance is. And then we come in, and everything that they said that they did on their own becomes our obligation, and they wash their hands of that. But they didn't do that. They only did it well after the scope of work that we bonded was completed and fully paid for. I hope that answers the question.
You good?
Thank you.
Okay. All right, you have 2 minutes.
Thank you, Your Honors. And if my able opponent is submitting a letter, we'd also like an opportunity
Of course.
to do so. Okay, thank you. Just to address, Your Honors, a few questions. I think Your Honor asked the counsel about what was their reaction, and he said, we didn't know anything. That's completely dispelled by their brief. I'm looking at page 10 of their brief. After they go through that on June 1st, 2018, JDS gave notice to Allied World that it was considering declaring the default. It actually declared a default in August of 2018. They say by letter dated August 24, 2018, this is on pages A213 to 214 of the record, JDS forwarded to Allied World the below damages calculation, which described a detailed summary of the damages incurred by reason of the default in performance of Parkside, and for which a demand was made against a reference bond. They knew, indisputably knew.
Counsel, do you acknowledge that if you want to recover these delay damages, at some point you're going to have to notify the surety, as you did, that there's a default? That in order for you to ultimately recover on this performance bond, you have to contact the surety and say, hey, we have declared a default under this contract.
I don't think we are required to do that under this contract. If you look at,
Why did you do it if you weren't required to do it?
well, we did declare a default. You know, remember, there was one contract at issue with Parkside. Their contract is to the.
When you declare a default, there's a provision where when you're considering declaring a default, that there's something that you have to do as part of the bond agreement.
Well, when we declared a default and sought to replace them as the contractor, yes, we did provide notice.
But you sought to replace them after the work that was the scope of the bond agreement was already completed. So what's the default?
Well, the default, it's the breach of the construction contract, indisputable breach, the delayed.
But what are you replacing them for? You can't replace them now that the work is already done.
Well, as your honors may have seen in the
It
briefing,
seems like it's like a legal fallacy that you've tried to create.
Well, it gets, respectfully and candidly, it gets confusing because there's one contract with Parkside, right? And that's to provide the entire
We're only
superstructure.
talking about
36th and 86th floor.
What's
It's
the
the
subject of
36th
the
and
bond
86th
is
floor.
the real question, right? What's being bonded that you're looking for money from the surety for?
What we're looking for are the delay damages that they agreed, that the surety agreed to protect and stand in the shoes of the defaulted contractor. Under their contract, they are standing in the shoes.
You
Can I
accepted
ask?
the delay by allowing them to finish the work without giving any notice that you were considering a default.
I would respectfully disagree with that. We accepted. Under the construction contract that they signed on to, we had the right, it's under paragraph 25E, to seek delay damages. Doesn't say we have to declare a default. In order to get those damages are recoverable as a matter of contractual right. The surety agreed to these terms, is there as a backup for a contractor who doesn't perform.
And you're saying that under this surety bond, the surety agreed to ensure delayed performance without notice of those delays?
Yes, Your Honor, that under this particular contract, which is incorporated into the terms of the bond, yes.
So how do they mitigate? How do you give them an opportunity to mitigate this issue?
I'm going to struggle to answer this question because I don't think we're required to under the construction contract, right? We're talking about an incorporated construction contract that we aren't required to give notice to the surety under the contract, under the construction contract. We are required to do so when we're contemplating defaulting and replacing
They're not
the
a party
contractor.
to the construction contract, correct?
They're not, but they sign on to it. They see that they certainly got the contract before they issue the bond.
So
Bond
you're
is
saying that the
attached.
construction contract provisions that they're not a party to supersede the provisions of their bond contract with you?
I think
Or with
what
your
we said.
client, not you personally, obviously.
Well, I think with respect to well-settled New York law, an incorporated construction contract into a bond, they're read together. And this contract, the contract is certainly.
So if one says you have to give me notice and the other one doesn't, which one wins?
Well, one says you have to give us notice in a particular circumstance, and the other one doesn't. If that particular circumstance doesn't happen, which is what we say here, we didn't have to give notice of a delay. We had to give notice when we were contemplating declaring a default.
How do we know when, how does a surety bond company assess when a construction real estate developer is considering declaring a default? That seems to be like a moving target.
I think that's right, Your Honor, is that this bond gives us that ability. It says when we are considering to declare a default. Delay damages are different. We don't need to declare a default in order to get delay damages. And I'm, again, going to refer back to paragraph 1 of the bond. It's on Appendix A198. It says that the contractor and the surety jointly and severally bind themselves, I'm going to leave out some of the other language, to the performance of the construction contract, which is incorporated herein by reference.
Okay.
There has to be language, that language has to be given effect. And we respectfully submit it can be read together, that when we decide to replace the default, when we decide to replace Parkside, we are required to give notice. We're also, I think we have to, there's a termination procedure.
There's certainly on notice of everything that's in that contract.
Correct. They're on notice of everything in that contract. They could have endorsed this bond to say something different than what they did.
Although the situation here is further complicated by the fact that you have two contracts. There's the 36-4 contract and there's the 86-4 contract.
I will say I agree with you, Honor. It's further complicated, but the principles are still there. The contracts are the same, ultimately. The only contract that was entered into between JDS and Parkside goes all the way up to the 85th floor. I don't think there's any dispute in the record in that. The sublimit to the 36th floor still doesn't change the fact that they are bound, the surety is bound by that contract. Now, they could have done something differently, but they didn't do that here. And therefore, they stand in the shoes of the defaulted contractor when we come to seek the delay damages that Parkside indisputably caused.
Thank you.
Thank you very much.
Employee retirement versus Varvel and others. You may proceed.
Thank you, Your Honor. Good afternoon. May it please the court, Jason Hall on behalf of the appellants. This is a derivative action. We submit respectfully, Your Honors, that this should be dismissed on forum nonconvenience grounds and also for failure to plead the breach of fiduciary duty with particularity as to any of the 19 defendants named in the complaint.
Why don't we deal with the forum nonconvenience first?
Yes, Your Honor. It's a bit of an odd situation on the forum nonconvenience. In this case, we have a dismissal, a denial of our motion to dismiss, which follows or is followed quickly in only a matter of weeks by a grant of a separate motion to dismiss on a forum nonconvenient motion.
So why isn't that a totally different case with totally different factual allegations, totally different scenario? The whole basis for this decision was because so much of the cause of action involved events that took place in New York, when the other case, it involved events which took place all over the world and not in New York. So how can anything decided in that case have anything to do with what's decided in this case, since clearly this is a very fact-intensive analysis?
We agree, Your Honor. It is a fact-intensive analysis. We do think that there is inconsistency as between the two opinions, but I'll move directly to your main question, which is the New York issues in this complaint. Frankly, Your Honor, we think that there's a disconnect between the allegations, the factual allegations of New York events in this complaint, which indisputably there are operations in New York of a subsidiary of this entity.
Doesn't this case have to do with the prime service business? Isn't that what this case is about?
Your Honor, what this case is about...
Isn't that a business that took place in New York?
The prime services business took place in New York and elsewhere, but what this case is about the management of Credit Suisse by its board of directors and by its executive board, which largely does not take place in New York. There's not a breach of...
Weren't the risk management decisions about the prime services business taking place in New York?
Board directors do not get involved in the day-to-day operations of a corporation. They don't. They just don't. So an attempt to say that the risk management operations of this prime services company somehow was actively controlled by the board directors in Switzerland is just not true.
Well, Your Honor, I would answer that question in two different ways. The first way is, and Your Honor is absolutely right, the board of directors is several levels of hierarchy above the issues that are actually
And they don't deal with day-to-day operations, risk management decisions. That's all by the CEO, the CFOs, and the CMOs, all of those people who actually run the day-to-day operations of the company. So let's dispense with that.
Well, the problem we have with dispensing with it, Your Honor, is that the board of directors, the 19 individuals in this case, comprise executive board members, the CEO, and others on the
All of whom will be flown here by Credit Suisse on the corporation's dime. So there is no financial hardship to not one singular person on that board.
Well, Your
Not
Honor,
one. So tell me why it is such a hardship for the chairman of the board, for instance, because you don't need all 19 board directors to testify about the board action here.
well, these individuals are personally exposed to liability, Your Honor. We submit that ultimately many of them,
The three named, you're saying, in the action?
No, I'm talking about the 19 defendants in the case. But the form
They're
non-analysis.
personally liable?
Only 3 of them are here now, so let's talk about the 3, because those are the only ones who have
Sorry.
appeared in the action.
Go ahead.
Which question to answer? There are 3 defendants who are appellants in this case, who are movements on the underlying motion. There are 19
Let's
defendants.
focus on the 3, because we're only dealing with the 3, because they're the only ones who have made this motion to dismiss, right? They're the 3 defendants who have made this motion, so they have to make the arguments that they can make as the ones who have appeared and are making the argument.
But respectfully, Your Honor, they have to make the argument as to whether the case should proceed here or whether the case should proceed elsewhere. It's not just about them, right? This case isn't going to proceed in New York as to some defendants and
Okay, so
elsewhere as to others.
you look at, it's not just the parties, you look at where the actions occurred, and if the actions have to do with decisions made in running that particular business and the risk management decisions made as to that business, and that business took place in New York, what would be incorrect about having this action in New York?
Respectfully, Your Honor, we think that implicates the second part of our argument. None of that is alleged in this complaint. There's no dispute. We don't dispute that they allege New York events in this complaint. What they don't do is link New York events to any of the named defendants. These movements, these appellants, or any
Several
the
of
other
them
named
worked
defendants.
here, right?
Some of them worked here. Their
Two
conduct,
out of the 3 worked here or resided here,
correct.
correct?
One of
Okay.
whom, by the way, is a technology person who probably doesn't owe fiduciary duties to the parent company, whose conduct isn't alleged at all. All we know is that she worked
That's
here.
not what's being argued in this case. I mean,
It
right now,
is.
we're just, but not in this motion.
It is.
This is form nonconvenience.
We have 2.
Was that spelled out in the papers below? I don't recall seeing that.
Indeed it was, Your Honor. And in fact, it's in our reply brief on this appeal. We argue, this is the pleading issue.
Right.
Right, the pleading issue is separate grounds for appeal. We think the district or the trial court applied the incorrect standard, didn't apply 3016B, which should apply in evaluating a fiduciary duty motion to dismiss. It should be pleaded with particularity. There should be clarity as to which
But
defendant
it's
did what.
based on a negligence standard, correct?
The claim is for breach of fiduciary duty.
A negligent breach of fiduciary duty, correct?
We disagree. that-
Counsel, am I correct?
No.
No, that's not what the pleading says?
The pleading alleges a Swiss law claim for breach of fiduciary duty. The plaintiff argues that there's a negligent standard of liability that applies to that
So
fiduciary.
then the answer to my question was yes, that's what the plaintiff alleged, a negligent violation, correct?
It's a
Whether
question-
you agree with it or not, that's what he couched it in, correct?
The plaintiff alleges breach of fiduciary duty. There's a question, a law, legal
That is the
question.
law under Swiss law, isn't it, that negligent breach of fiduciary duty?
Under Swiss law, as under New York law, there's an objective standard that applies to evaluating the conduct of officers and directors with a business judgment rule overlay. We don't agree that that should be properly characterized as negligence. It's a legal question.
All right, you'll have time on rebuttal.
Good afternoon, Your Honors. My name is Jeroen van Kwaawegen from Bernstein Lewis on behalf of the plaintiffs. I'll take the issues in the same order that my colleague on the other side did. He started off by talking about the Catton case, and Your Honor pointed out that the facts there are totally different. Not only are the facts totally different, it's the same judge. And it shows that Justice Masley was very well aware of the various factors that she's supposed to be applying under the Iranian Republic case. The 6 factors. She applied them there, and then she applied them here. And that's exactly what she's supposed to be doing under the governing laws for the Court of Appeals and this department. So not only are the facts totally different, it actually shows that Justice Masley did exactly what she was supposed to be doing here.
What's your response to you're suing the board of directors and top officials at Credit Suisse. Credit Suisse is clearly a Swiss bank. The board of directors clearly met in Switzerland where they made a lot of decisions that are being challenged here. Why not? Why not Switzerland?
So a couple of responses, Your Honor. First of all, we're suing them, not just the board of directors, right? Also New York-based defendants for acts and especially failures to act here in New York that caused the implosion of the prime services brokerage business here in New York. And so we're not talking about particular decisions that were made in Switzerland. We don't concede that the wrongful acts were exclusively located in Switzerland. We're actually saying the wrongful acts and failure to act and negligence happened here in New York, and a number of defendants, a majority of defendants, have direct New York ties. There's no hardship, and there's absolutely no reason why this case should not be proceeding here. Another reason is, and Your Honor saw that in the papers, another reason is Swiss law does not, and Justice Masley did an analysis, looked at the competing expert reports. Swiss courts here in this particular case do not provide an alternative forum. And you would say, well, you know, how do we know that? Well, we know that because there is no other case pending in Switzerland. And this is not just some minor action. This caused the implosion of the prime brokerage service business here in New York, $5.5 billion of losses. If there was a viable claim to be pursued in Switzerland with the Swiss courts, somebody would have done that. But as Justice Masley accurately notes, that is just not the case. She looked at Dr. Blank's report, our expert, she looked at the defendant's expert report, and she said, you know, I'm looking at the costs that the Swiss courts would be imposing, and $27.7 million just to put up to start this case seems prohibitive.
They're not fond of shareholder derivative actions there.
Well, they provide it under the law, and so it exists, but it's not really well used. And then, you know, Justice Massey looked at the defendant's report and said, you know, the only example that you give where there was a reduction of those costs is a voting rights case, and there's only one. And so, to answer Your Honor's question, there's multiple problems with moving this to Switzerland, including the fact that Justice Masley actually just got it right when she applied the factors that she was supposed to be applying in this case. Now, Your Honors, I saw that this was the panel, so I looked up some of your decisions, and one of the cases that we cited was Hyung Long.
Mention the case I was reversed. No, okay.
This is the Morgan Stanley, I'm going to mispronounce the name. It's the Morgan Stanley case from the First Department in 2015. I'm aware that not all of Your Honors were on the bench at the time, at least not on this particular bench. And at least the two of you, Justice Friedman and Justice Manzanet, you said, look, unless the judge below did not apply all the factors or discretion was improvidently granted, the decision below should stand. And I respectfully submit that that's exactly what happened here. If you look at Justice Masley's opinion, she did what she was supposed to do, went through the factors, and she did not improvidently deny the motion to dismiss.
Argument about the breach of fiduciary duty, that this isn't really a negligence claim, and it's really a breach of fiduciary duty claim.
Right, and Your Honor, so my answer is, I don't think there's a lot of dispute here between us and the defendants. I understand that they would like to recharacterize things, but there's no real dispute. The defendants concede that if you have a simple negligent claim under New York procedural law 3013, that you know, you're not applying the heightened pleading standard. No dispute. There's also no dispute that based on the internal affairs doctrine, the court below will apply Swiss law. We put in an affidavit from Dr. Blank saying, Swiss law breach of fiduciary duty claims arise out of negligence. No dispute. Defendants conceded in their reply brief below, the record is 1113 in this court, that Swiss law imposes liability for negligence. So what they're trying to say is, well, no. We're going to instead say, well, this is a breach of fiduciary duty claim, and that must always be subject to the heightened pleading standards. And that's just not the law, Your Honor. If you look at 1316B, right, that applies typically to breach of fiduciary duty claims before this court where you have disloyalty, where you have fraud. For example, if Your Honors look at a Delaware case, well, negligence is exculpated under the charters of the Delaware companies, so there's always going to be that heightened pleading standards. But this case is unique in that sense that Swiss law does not require fraud, does not require willful misconduct. You can actually have a breach of fiduciary duty claim based on negligence. And if you look at 3016B, that is the language, right? We're going to look at what the claim is based on. And this is clearly a claim based on negligence. And if you then look at our complaint, there's a whole section where we say, it's paragraphs 51 to 59 of our complaint, the Credit Suisse director's negligence-based duty of risk management under Swiss law. So, Your Honor, if you look at the complaint, what we allege, the concessions that the defendants have made, this is a negligence claim. Subsidiary argument, I also think that we actually satisfy the requirements of the 3016B, so it may be an academic debate, because if you look at the detailed allegations of our complaint, there's absolutely no misunderstanding. But what we are alleging the defendants, all of them, including the New York-based defendants, did wrong here.
Thank you. You have 1 minute.
Thank you, Your Honor.
What's your response to his argument that the court did look at all the factors that it was supposed to look at, in particular that there really is not a viable alternative forum in Switzerland where it is very difficult to bring a shareholder derivative suit, and applying all those factors decided it was appropriate to keep the case in New York, including the wonderful commercial courts we have in New York, which can handle these kind of disputes?
Your Honor, two things. First, this court can exercise its own independent discretion in assessing the forum nonconvenience factors. That's at page 13 of our opening brief, the Shinetsu case from 2004. On the question of whether Switzerland is a viable alternative forum, this court and other New York courts frequently send cases, including shareholder derivative cases, to Switzerland, acknowledging that it is an adequate alternative forum. This trial judge sent another shareholder derivative case involving Credit Suisse to Switzerland, acknowledging that it's a valid and viable alternative forum. She rejected in that case the argument that she accepted here, which is that the costs are prohibitive. She explicitly rejects that same argument in that case. And the reality is, Your Honor, it's a bit of a straw man. The plaintiff erects this notion that $27 million will be charged in court costs in Switzerland. They don't have a single case where anything even remotely approaching that has been told against the plaintiff in a derivative case in Switzerland. The Swiss courts have extensive discretion in the interest of justice to set court costs, as courts do here. If the plaintiff is unable to pay, it's not a formulaic exercise. It's not a question of just...
Have the parties already engaged in significant discovery here in New York?
Yes, Your Honor. 2 points on that. The plaintiff has been focused...
I just wanted to know whether that happened.
They have, and there's extensive additional discovery from Switzerland that hasn't taken place yet.
Okay, thank you.
Thank you.
Rosenberg versus OSG.
Good afternoon, Your Honors. May it please...
Wait for your adversaries to get up.
I'm sorry.
We're not as quick as
That's okay.
Now you may proceed.
Thank you, Your Honors. May it please the court, my name is Morty Yankovich with Liebad Law PC. I represent the appellants in this matter. We respectfully submit that the lower court's decision dismissing all the claims should be reversed because the pleadings here, assuming all the facts to be true and interpreting every inference in my client's favor, which is...
Can you tell me where in the pleadings it is alleged that your clients were employees? Where there was, or that you give me any factual allegations setting up an employer-employee relationship?
Yes, we do. New York Labor Law 651.
I'm talking about with respect to your clients and the leadership of this organization. What interaction between them, what conversations, what writings would help support a finding that at its inception, they were entering into an employee-employer relationship?
Well, so we submit that the primary beneficiary test should be applied here, and the primary beneficiary test is a multi-factor totality of the circumstances.
How is this different from the countless hours that so many of us on this bench spend on bar association activity and judicial association activity, where we lend our work, putting together galas and conferences and CLE programs at no charge. And we work hours putting those things together over months.
Right, well,
Right? So, and I pay a membership fee to those organizations as well. So explain
Correct.
to me how this relationship is different from what I've described.
So its relationship is different because in your case, you're volunteers for presumably a nonprofit organization, and you are also receiving some benefit. Here, my clients were indoctrinated and manipulated and coerced to
That's
perform
not what you're
labor.
suing for.
Correct, correct. And they were manipulated and coerced into performing hours of free labor, and the benefit was solely the respondents. It wasn't, our clients did not benefit. They were promised a educational experience and self-improvement courses, and all they got was indoctrination, manipulation, and they suffered psychologically and emotionally. And for the primary beneficiary test, there doesn't have to be a contract of employment.
Isn't that a case, that's a federal case having to do with interns and internships?
Correct.
So how did that case even apply to a case such as this, which has nothing to do with whether or not an intern is an intern versus a worker?
Because in intern cases, as well as the vocational cases, there's a cosmetology trainee case, as well as the wife of a superintendent. In all those cases, similar to this case, there was no expectation of wages. However, based on the primary beneficiary.
This is not an internship case where we're trying to make a determination whether or not an
Correct.
intern should be a paid employee. That case was very specific to those cases.
Right, but I submit that it's been applied in other contexts, and I do recognize that this is a case
It's been
of
applied
first
in any
impression.
labor law cases under New York State labor law?
So it's been, correct, these federal cases apply it to New York State labor law, 100%, and they have persuasive authority. Lower courts in New York have applied the primary beneficiary test to interns. It hasn't been before the appellate division, but I
No,
submit.
but the issue here is not interns. You're not making an argument that they were interns.
No, no, I'm arguing that
I'm just not sure why that test.
because they performed labor.
But they were also, they voluntarily went to this organization. You're not suggesting they were forced to come and join OSG of their own accord for whatever reason,
Well,
right?
well,
They come and they join this organization, right?
yeah.
And then in the course of, and they pay a membership fee. An expensive one, but a membership fee nonetheless.
And we're claiming
right?
that was fraudulent.
Okay, and then in the course of their membership, they start participating in activities of the organization, right?
Correct.
And you say they were coerced.
Yeah, they were duped. Yes.
So when you say coerced, what, at the threat of what? Were they coerced to come and plan a gala, for instance?
Right, they were coerced. Well, the way cults operate is they manipulate you into thinking that you have to rely on them and they're your sole existence. And they were coerced into believing that if they were kicked out of this cult, it would ruin their lives. So, and the coercion isn't a dispositive, while there was coercion, it's not dispositive here.
Turning your attention to something else, can you plead fraud on information and belief?
You can plead it entirely upon information and belief, but we only have, I believe, 2 allegations that are pled upon information and belief. The rest are pled with particularity. We plead material representations of fact, we plead justifiable reliance, and that goes to the core here, that this shouldn't be a factual assessment at this point. It's a motion to dismiss. So we plead all these elements, and they need to be presumed to be true at this stage.
So the misrepresentation was if you join this organization and partake in our educational programming, your life is going to improve. That's what they were promised.
Self-improvement education, correct,
Okay.
and pay $400
So
a month.
how do you assess self-improvement? How does, what subjective or independent test could we employ to determine whether somebody's life has been improved?
Well, I submit that somebody who's been manipulated and indoctrinated.
No. I'm asking about what equals improvement? A better job? I find a husband or a wife or mate? What's improvement?
Some curriculum, some education, some real coursework related to self-improvement. Here,
But again, doesn't self-improvement have to be defined in some way for the court or jury to measure it?
I don't necessarily think so, no.
So is self-improvement a subjective measure? If they don't feel that they have been improved, that's it?
They were,
Or is it an objective measure?
they were promised an education and self-improvement, and they did not receive it.
My question was, what is the standard, subjective or objective?
I think it's a combination of both.
Okay. You'll have time on rebuttal.
Okay, thank you.
May it please the court, Judith Richmond for respondents. We have heard now something from appellant that we didn't hear before even. This complaint has no facts in it upon which to state a cause of action. We have heard that there are
Well, what exactly was the organization offering concretely that could develop into self-improvement of its members?
well, the organization is, as they say, a reading group that they joined.
A what?
A reading group that they joined.
So you read to self-improve?
Whatever.
I'm just trying, I'm not being facetious because he's saying you did nothing to help them improve. So I'm asking you, what was it that the organization offered to the tune of $400 per month, $400 a month or $4,800 a year? What is it that their members got other than going to a meeting every 2 weeks and being asked to do things on behalf of the organization?
Well, if they improved or didn't improve or enjoyed it or didn't enjoy it or liked what they were reading and liked what they were discussing, that's certainly a subjective view. And if you like it, you continue. I assume you don't like it, you don't continue. But this is a claim for employment. This is not a claim of what all of the other, frankly, sort of lurid, allegations that they have included in the complaint state. There is nothing in the complaint that specifically says that any of the specific defendants said anything, offered anything, determined anything, that these people worked for any specific time doing any specific job, whether it was in 2005, which they allege when they joined, and they alleged that it was non-defendants who told them that if they joined, their lives might be improved, which of course is, as you know, a violation of statute of limitations. And they even say that the defendants, including somebody that they say had nothing to do with the group, who's only in the estate, an executive of the estate, is lumped together with over 15 years of non-specific claims. So, and this is a claim for employment where they then say that none of the employment law cases matter. In the respondent's reply brief, they say that they do not matter because these cases are unavailable in the context of a non-traditional relationship in the instant parties where there is no arrangement to hire the individuals as either employees or independent contractors. So they admit in their own brief that they were never hired as employees, they were never hired as independent contractors, there was never a discussion, not even non-payment, but in frankly, 20 years, that there was never a discussion of being paid. And therefore, nor does it say, as I say, any time, space, specifics of any individuals who allegedly did anything to control these people or what they did. If they set up a meeting or broke down a meeting, I don't know if they set up a meeting or broke down a meeting, where the meeting was, when the meeting was, or who allegedly told them to set up a meeting, bring chicken salad, or bring it home, or anything else, because it's not stated. You cannot have a complaint, which is what Judge Sattler said, which has no factual basis. And given every conceivable factual basis and given the benefit of the doubt, there are no facts there. And this is now, as I say, I mean, many, many, many years where there wasn't even a request, as they say, a discussion or request for any employment. There is nothing also having to do with any of the fraud, which my colleague can speak to, but there was nothing, no specifics, no specific pleading, no specific allegations on any of those issues. And as such, they have not brought a claim which is sustainable. And I will let my colleague, sorry I took so much time. So she will
How many so you're here for whom?
We have a joint defense agreement, so it is.
I wish you had told me that because you used up all the time.
I apologize.
I don't know what else you want to add. I'll give you a minute.
I'd just like to state that with respect to the fraud claims, Your Honor is absolutely correct. It's a subjective standard. It's at best perhaps an opinion and something that's going to happen in the future, and none of those are sufficient to bear a fraud claim. And with the other state law claims, the unjust enrichment and the quantum merit, the same thing applies. They haven't alleged sufficient facts for the contract or fraud claims, and the quantum merit and unjust enrichment fall for the same reason.
Thank you so much. You got it.
Okay, counsel, I'm looking at your complaint starting on the record, page 75, starting with paragraph 73. Where in the complaint have you stated any factual allegations that would suggest that your clients were made to believe that they would be paid for the work that they did? What number, starting with number 7?
No, so that's the crux of my argument, that there wasn't an expectation of wages, but that's not required under the primary beneficiary test. We cite to numerous cases where there was no expectation of payment, like intern cases, like the cosmetology trainee cases, like the superintendent wife cases, where there was no expectation of payment, but because they performed labor, and here...
That would open up to every single not-for-profit organization and membership organization, just as I said at the beginning. For every single organization that has a member help participate in moving the organization forward, now this organization has to worry about and consider getting a release from a member saying, we're not going to pay you for your volunteer on this committee.
Well, you need to be careful, but a lot of those would be covered under the volunteer exception, which applies to nonprofit institutions. If you're performing labor for a for-profit institution that they would have to otherwise pay somebody else to do, then that's an employee relationship, regardless if there was a
There don't have to be a discussion. Don't worry, you help me, I'm going to take care of you later, nothing. Just I do, and now you have to pay.
No,
that's what you're saying.
I'm not. The analysis is who benefited from this labor. They're performing menial labor.
In the setup of an organization, if I, as a member, participate in helping the organization with an event.
But that's not this. This is a cult. That's what we're alleging. That's a factual determination.
That's your allegation.
Exactly, and it's a factual determination.
All right.
We stated our causes of action.
Okay. Thank you.
Thank you.
Devlin versus AECOM. Okay. And you are for?
Good afternoon, Your Honours. My name is Neil McGillivray. May it please the court. I represent plaintiff appellants.
Okay, I just want to make sure I know who I'm talking to. Go ahead.
Your Honours, obviously we have quite a number of defendants in this case. I'm going to focus primarily on two of them for today, in that obviously the briefs, I think, comprehensively address all the various issues. But again, for today, I'm going to focus on two of the defendants. So the first one is AECOM. Now, AECOM here, they were the construction manager on the job. They were in charge of worksite, or worksite, I should say, safety. The lower court, it addressed, there were claims under Labour Law 240 and 241.6. The lower court did address those claims, it dismissed them. I'll get to that. But what it didn't do, it completely overlooked the negligence claims. So there's a common law negligence claim, a Labour Law Section 200 claim. And the reason that's particularly important is this. Those claims are divided into two categories. Means and methods cases on the one hand, dangerous condition cases on the other. This was a dangerous condition case. It's a hole that was cut out a number of weeks prior to the accident, into which plaintiff John Devlin ultimately fell. It was a hole that was cut out. There was a single unsecured piece of plywood placed over the hole, and Mr. Devlin fell in and suffered particularly significant injuries. And in terms of AECOM, where their liability springs from, the lower court focused on whether they had the authority to control and supervise plaintiff's work. In dangerous condition cases, that's not.
Well, why don't you address it? What's your argument as to why AECOM was responsible for creating the hole?
Well, it's not responsible.
200 or negligence.
Right, not responsible for creating, but what it had was, I'll go to the patent jury instruction. In dangerous condition cases.
Yeah, but I think you really have to focus on the contractual language in this case, which is very specific and clear.
Right.
Okay, and the contract very clearly said that they were not responsible for taking care of. They had no authority to stop the work, and all they could do was report it to Stalco, who then had to remedy the situation. And in that kind of fact pattern, our case law has been clear that that's not enough to impose liability on a project manager or construction manager that did not have authority to stop the work.
To stop the work. I agree with that, Your Honor. But the thing is that, so what the contract says, and the exact same contractual provision was addressed by this court in the Minorsik case. It's exactly the same language. In terms of the facts of this case, AECOM did stop the work because of a dangerous condition a number of weeks. No, the accident here happened, I believe it was December 17th, 2015. They stopped the work a month earlier, on November 12, 2015, because a separate dangerous condition in the exact same location. Mm-hmm. So they did have the authority to stop the work. It's in the record, I think it's page 5,749. It states, it's the AECOM log for that day, and it states, and I'm reading, that work stoppage issued by AECOM field super. So they did have the authority to stop the work. And not only did they have the authority to do it, a month earlier in the exact same location, they actually did stop the work. And in terms of what's required for purposes of common law negligence, and Section 200 negligence too, AECOM in this case, they need to have control over the area where the dangerous condition existed, along with notice. They had that. They had control over the area. That's demonstrated by the fact that they stopped the work a month earlier.
Didn't Stalco testify, though, the supervisor, that if they found a dangerous condition, the responsibility was to go to Stalco and say, hey, there's a dangerous condition. It wasn't their responsibility to correct the dangerous condition. That was outside the scope of their function.
Well, I would say this, Your Honor, I mean, that's a classic issue of fact. And
But wait, what the contract says, we don't have the authority to stop the work. The construction manager's guy testified their job was not to stop the work. Their job was to go to Stalco and say, hey, Stalco, there's a problem here. So if all the evidence in the record, the contract and the testimony, is that it was not their function to stop this work, then why is it an issue of fact?
Because that's not the entirety of the evidence in the record. The evidence, the record, whatever the superintendent said, what actually happened on November 12, 2015 is that it wasn't Stalco who stopped the work, it was AECOM that stopped the work. And in terms of the
Do we have that in the record?
Yes, again, it's page 5,749. It's the AECOM log from November 12, 2015. And again, I'm reading what it says: work stoppage issued by AECOM field super. And in terms of the, as it were, the division of labor, division of responsibilities as between AECOM and Stalco, where Stalco had responsibility was over, as it were, means and methods, meaning that if the job
Stalco was the GC.
Excuse me, exactly, no, excuse me,
Right.
exactly, Your Honor, in that that's where they had authority to intervene. But AECOM were given the responsibility over the condition of the job site. So to the extent that you have a dangerous
But they were not declared the safety. Were they given responsibility over safety?
Yes, they were. And not only that, Your Honor, they hired, under their contract with DASNY, they were given the option to hire an additional site safety
Well,
consultant.
they had to, right?
They did,
Yeah.
again, under their contract to assist them in carrying out their duties. So those were their duties under the contract. Again, the exact same provision in the Minorsic case before this court. There's a Barrios case before the Second Department. It's cited in the papers. Again, it's another construction manager contract in that case with the city of New York. Seems to have identical language, identical circumstances. What we would say here is that, and again, the DeVita, this court in the DeVita case has said that you can be a statutory agent for a dangerous condition agent's case, but not a means and methods case. You can be a statutory agent for purposes of a negligence case, but again, not a 240 or a 241-6. What we would say here is that without question, they were a statutory agent for purposes of the negligence claims that were based on a dangerous condition. We would also submit that they were...
So if they had no duty to stop the work, and it's clear that under the contract that was not their role to stop the work, and they had no duty to. If they have no duty to stop the work, what's their duty to correct dangerous conditions under the law? Because they're not the owner, they're not the general contractor, they're a construction manager who does not have a contractual duty to stop the work.
Well, Your Honor, they're an agent of the owner.
Well, the finding below, and you're not arguing to the contrary, is that they're not an agent for purposes of 240 liability or 240.
No, I am arguing, Your Honor.
That's not the argument you were presenting. The argument you seem to be presenting, which I assume means you're not making the other argument, is that they have common law liability. You haven't been making the argument to us that they're statutory agents for purpose of 240 liability. Maybe that's not because it's one of the areas you want to focus on today, but it's...
Well, let me tell you exactly what the argument is. My starting point, or our starting point, are the negligence claims. And we're saying that on the one hand, you have means and methods claims, dangerous condition claims. We agree with the lower court. To the extent this was a means and methods case, AECOM is not an agent for purposes of our negligence claims, but it's not a means and methods case. It's a dangerous condition case. When it comes to 240 and 241-6, that distinction doesn't exist.
Right.
What we're saying in that regard is that if you look at this court's decision in the Minorsic case, and that's one where the lower court there found exactly the same as the lower court here, which is that because it didn't have authority over, or it didn't have the ability to control plaintiff's work, therefore it wasn't an agent. This court reversed. Exact same provision, exact same circumstance. That too is a dangerous condition case. And again, the Barrios case from the Second Department, I agree, Justice Kern, that it does very often turn on the contractual language. But in those two cases, well, certainly the Minorsic case that was before this court, you have the exact same contractual provision. And if you read from it, it's that and again, I'm reading from that case, but it's the same in this case, that the construction manager agreed to take every precaution against injuries to persons or damage to property and for the safety of persons engaged in work at the site and to establish and maintain safety procedures. That was the contractual language in that case. It's the same contract here. And again, I think the negligence claims are pretty straightforward. They were overlooked by the court below. I think it's straightforward in terms of every case simply looks for control over the area where the dangerous condition existed along with notice. That I think is straightforward. I agree, or I would agree, that in terms of 240 and 241.6, that is not a straightforward analysis, and there are cases that go in both directions. But this court, in the Minorsic case, considered the exact same circumstances, or equivalent circumstances in terms of a dangerous condition, the exact same contractual provision, and found that it was an agent. And I think this court should follow that case, because...
Okay. We are way over time, so you'll have time on rebuttal to discuss some of the other issues that you haven't hit yet.
May it please the court, Michael Kazoris from the Law Office of Eric D. Feldman on behalf of CUNY and Stalco. I just want to revisit the issue that Counselor for the Plaintiff was talking about with respect to ACOM. I could not agree with him more. I'll point out on page 12 of my reply brief, I quote a portion of the ACOM contract. It provided that ACOM was to, quote, take every precaution against injuries to persons or damage to property and for the safety of persons engaged in the performance of the work on the job site, end quote, and to, quote, establish and maintain at all times safety procedures in connection with the work.
Is there any evidence in the record that ACOM ever actually stopped the work or had authority to stop the work? I mean, ACOM employees all testified they didn't have the authority to stop the work. Where in the record is there evidence that they stopped work?
Counsel for the Plaintiff just gave a page in the record where they stopped the work.
I don't see, that doesn't say, hey, we stopped the work. It's a quotation that they said something about stopping work. How does that establish that they did stop work?
Your Honor, I think it was clear from the record that counsel cited that on that one instance they did stop the work.
I find it really, I don't know the circumstances there. I don't know whether Stalco, because according to the record, Stalco together with ACOM would walk around the job site together. And so to me, it's absolutely feasible that after a walkthrough, Stalco tells the ACOM representative, go and issue a stop work order over what we saw on X location. So without having more facts, that statement by itself doesn't convince me.
No testimony. All the testimony in this record is that they don't have the authority to stop the work. The contract, the employees, the testimony, the only thing he's citing to is the statement in the record, which is somewhat ambiguous. There's no testimony from anybody that they stopped work. Is there?
Yeah.
Do you have any testimony to point to that says, oh yeah, ACOM had the authority to stop work?
Nothing that specific, Your Honor. I would point out that Glenn Smith of ACOM did daily walkthroughs. They hired the site safety manager.
That they were checking out for safety, and we have a million cases about that, that the mere fact that they check for safety does not impose either 240 liability or common law negligence liability when they're not an owner or a general contractor or an agent.
Your Honor, I would just respectfully submit that based on the contract portions of which I've read here, I think they are the statutory agent of the owner.
The Supreme Court denied plaintiff's motion for summary judgment on the 241 claim on the grounds that there's an issue of fact. What's the issue of fact which supports denying summary judgment on 241? As to CUNY, you represent CUNY and Stalco.
Correct, Your Honor.
As to CUNY and Stalco, what supports denying summary judgment?
Denying summary judgment to the plaintiff?
To the plaintiff, yeah.
The fact that that there's this disputed issue of fact as to whether or not the plaintiff was the sole proximate cause.
How could he be the sole proximate cause when there is a violation by not having a barrier around the hole?
The hole was covered.
But it wasn't secured, so
Well,
you might as well have left it open. They would have at least had a better shot of knowing there was a hole.
the plaintiff put in the C3 accident report that he fell into the hole when he was lifting the
He
plywood
didn't
off
say
of
that.
that hole.
That statement of lifting wood is attributed to no one, and he didn't fill out that report. The part he filled out, he said he fell backward into the hole.
That's what he testified to, but he signed the accident reports that said that he was lifting plywood.
So the picture in the record where he draws a line from the crack in the pool wall to where he falls, so what it shows is that the plywood doesn't cover the whole hole.
Well, I don't know if we know when that photograph was taken, Your Honor. If the photograph was taken, it could have been taken after the accident.
But what we do know is that the board was not secured to the surface in any way. It was just thrown on top, right?
Well, there was testimony that the board was additionally covered with a manhole so that it couldn't be
That's
slid out.
disputed, isn't it?
Yeah, that is.
Well, it's disputed. It's a disputed issue of fact.
But what we do know is that somebody fell through the hole.
Is a
The
manhole
person that was
sufficient?
lifting the cover off the hole fell into the hole.
But is the plywood in a manhole sufficient? Is that secure enough?
If the plaintiff had stepped on the board while the manhole was on it, that board would not have moved.
Exactly. And the fact that it did tells me there was no manhole on it.
But there's testimony that there was a manhole on it.
No, there was no testimony from anyone who said that just before the accident, they saw this board with a manhole on top of it. Not one person. Not one.
There was a site safety inspector that inspected the area 15 minutes before the accident and noted no dangerous condition. And
Did
no
it
violation.
note that it had a board with a manhole on top of it?
It noted no problems with the area.
Okay, so that tells me nothing. Except that they noted nothing. And 15 minutes later, somebody falls 15, 20 feet down.
Because he moved the board. But thank you, Your Honor.
There's no evidence of that at all.
Morning, Your Honor. May it please the court. David Sasser for Gramercy Group. I'm substituting for Richard Leff on the briefs.
Okay.
So we are the respondent and appellant, but I wanted to focus on our arguments as an appellant. We believe the trial court erred in not dismissing the labor law claims against us, 241 and 241-6. Plaintiff testified that only his employer aimed, directed, and controlled his work. The trial court dismissed Safety and Quality Plus on that basis, and that was
So
all.
your adversaries make a whole to-do about the fact that you created the hole. Why is that not dispositive?
Yes, Your Honor. Well, we have to decide what the dangerous condition is. It's either the hole or the plywood protection. If it's the hole, there's no dispute that we were required to create that hole as part of our contract. We're the demolition contractor. We were not making holes willy-nilly. We were supposed to make this hole to put a hatch in there. And there's no, if we had done the hole negligently, there may be an issue there. If the hole was supposed to be 12 feet, or only 8 feet wide, and we made it 12 feet wide, potentially that could be a dangerous condition. There's no question that the hole.
The point is you did exactly what you were called in to do.
Correct.
And the contract didn't include covering holes.
Correct. The
Or
contract
providing
actually
a
has-
net.
The contract doesn't exclude, I'm sorry, Ms.
Or providing a net, a safety net.
Correct, Your Honor. It actually excludes fall protection. Under the exclusions explicitly, it's there plain as day. And because of that, we think, just based on the contract, we can't be liable for the state of the protections. There's also testimony from Mr. Chris Calford from Stalco that he would have had carved in stone, a non-party come in and install the permanent protection, essentially. So we think under the labor law claims for those reasons, it was not our responsibility. And on top of that, we were gone for 3 weeks. We did not have any of the control over the site necessary if there was an issue to fix it. And then as we stated in our brief, there's evidence in the record that multiple workers from other trades between the time we left and the time of the accident accessed the surge tank. The only way to access the surge tank was through that expanded manhole opening. So whatever was left there, they had to move it to get down into the search tank to do their work. The workers from Numberger Construction did work in there on December 10th. For the accident on December 17th, I believe Jasper White testified he was in the search tank at times. So there's no proof whatsoever that the protections that were there on the 25th of November when my client left were the protections that plaintiff encountered 3 weeks later when the accident occurred.
When I don't recall seeing this in the record, when your client finished the hole, did they cover it before they left the site?
So Mr. Calise, our witness, testified that he didn't remember the project. Again, they were gone before the accident happened, so it was just another project to them. But he testified it was always that they would do that it was their practice. They wouldn't just leave an open hole. It's our position that that would be the temporary protection until those responsible for coming in and putting the permanent protection would come behind them and do that.
Okay. Any questions? Thank you.
Thank you.
Briefly, Your Honors, may it please the court. I represent respondent AIM Builders. Stalco's counsel hasn't argued against my client, but did submit in his appeal that he wanted to overturn the lower court's finding that said that there was an issue of fact as to whether they were negligent and therefore they weren't entitled to contractual indemnification against my client. I argue in my papers, and I submit unless you have any further questions, that the lower court got it correct. Stalco inspected the site. The witness even testified that he, checked on this plywood. He stood on it. So there is an issue of fact that they were negligent in failing to ascertain whether this was proper plywood placement.
Wouldn't CUNY get conditional summary judgment against AIM because there's no view that CUNY was negligent? They're an off-the-scene owner.
Yes, we don't oppose that portion of their appeal.
Okay. All right. Thank you.
Thank you, Your Honors.
Okay. You're up first.
Your Honors, I'm just going to return very briefly to the AECOM issue.
I'd like you to at least address the 240 issue.
I will. Well, Your Honor.
I've never seen a plaintiff not hit the 240 first.
Well, Your Honor, I think as I was listening carefully to the earlier exchange, and I think what's clear from that is that defendants here have tried to raise various issues of fact. We don't think they're real, but the point is this. None of them go to sole proximate cause. Even if you take every one of the so-called issues of fact that they raise at face value, they only go to comparative negligence, in that once we establish, which we have, that you have a hole with a plywood, a single sheet of plywood that was unsecured on top of the hole, that was a proximate cause of the accident.
There's a manhole on top of the plywood.
Well, Your Honor, I think if you look at there are a number of photographs that were taken. It may have been Your Honor who asked or raised them before, and counsel had responded, we don't know when they were taken. Well, we do know when they were taken because some of them are time-stamped. So there's a number that are time-stamped.
The one I'm thinking of, I think, was a defendant's exhibit.
Right. Well, so there are photographs that were taken by Stalco, and there are photographs that were taken by one of plaintiff's co-workers. And what they show, in particular the co-workers' photographs, which are right after the accident, they show two manhole covers. These are the manhole covers that were cut out to create the hole back in November. Two manhole covers neatly stacked against the wall. Now, and in terms of the AECOM representative, I think it was Mr. White, who testified about seeing the manhole covers on top of the plywood. This is the same AECOM that wrote the word hole over the cover after the accident. Obviously, he saw the manhole covers there, realized that it was unsecured, and again, I'm hesitant to call him anything pejorative, but I will say this. His testimony is utterly incredible. What's more, there's nothing to indicate that even if you had, to your point, Justice Masnad, you have a manhole cover. First of all, his testimony was that the manhole cover was sitting right on top of the plywood. Now, you only have to look at the photographs to realize that were that the case, not only would it not prevent the accident, it would contribute to the accident. What's more, if it was sitting, if it was in fact where he said it was, it wouldn't have somehow magically found itself neatly stacked against the wall with the other one. It would have landed where Mr. Devlin landed, in the hole. I don't think that there's any issue of fact there to begin with, but it's certainly not an issue of fact as to sole proximate cause. Whatever they have raised or whatever issues they've raised in terms of Mr. Devlin, they only go to comparative negligence. We don't think they're real issues to begin with. But in terms of 240, I think it is quite clear-cut on the record that the unsecured plywood cover was a sole proximate cause of his accident. Therefore, summary judgment should have followed. Now, in terms of Gramercy, they make a number of points about their contract. The contract has 2 exhibits to it. Exhibit A1, it has, I think, 30-something, it's a single page. It's a proposal with the scope of work plus exclusions. I think there's about 30 different exclusions in small print. One of them is fall protection. The problem for them is that there's another exhibit, Exhibit F, which is a safety plan they had to prepare, whereby they had to identify fall hazards and specify how they would guard against them. It's a basic principle of contract law that the specific, in terms of conflicting provisions, the specific always supersedes the general. I would say this too. This is a classic Espinal case.
I don't understand how outlining as a part of their work, they create a hole that they know if it's not secured is a danger. So I don't see any problem with them saying, by the way, in this contract, you haven't hired us to provide you with fall protection, but this is what's needed here.
Right.
How does that make them liable?
Well, Your Honor, I think it was yourself, if I'm remembering correctly, and Justice Kern, there was a case before this court, the Ferrugia case, which involved an oil tank. Contractor came in, moved the oil tank. That was the job that the contractor was hired to do. Underneath the oil tank was a hole. Somebody fell into the hole. And the
case didn't have a clause saying they're not responsible for covering the hole.
No, but the contractor in that case raised exactly the same arguments as Gramercy are doing here. What it said was, our job was just to move the oil tank. It wasn't to cover the hole, just to move the oil tank. We performed according to the contract, et cetera, et cetera, et cetera. And what this court found is that you created a dangerous condition. You left
I don't think that those facts are on point with this case at all.
Well,
here they were hired to make the hole.
Well,
in that case, they were hired to remove a piece of equipment.
Right.
When they removed it, the owner or whoever told them to remove it would not necessarily know that underneath this tank there's a hole. That once you remove that tank, somebody should cover it up so nobody gets hurt. Totally different. I don't see that as...
Well, Your Honor, I would say this.
I'm going to give you 30 more seconds.
Thank you, Your Honor. In terms of this case, if you look at the testimony from Vincent Calise, so that was the Gramercy super on the job, what he says quite clearly is, and he spoke about his long experience doing the job, he said, if we cut out a hole, such as this hole, we cover it. That's our job. That's our responsibility. And I will also say, pardon me for returning to AECOM, in terms of evidence in the record, he also said this in terms of AECOM. They were the safety unit organization on the job. They instructed us, this is Gramercy, as to safety issues. Again, in terms of who was responsible as between...
Counsel, you can't go around the contract exclusions. I'm sorry.
Well, Your Honor...
We've heard your arguments. Thank you. You out of time.
Thank you very much.
Please have a seat. You're up.
Your Honors, thank you. I just want to use the balance of my time to address the contractual indemnity issue that we have with AIM. Justice Friedman raised the point of condition. Well, they conceded conditional contractual indemnity. As to CUNY. I don't think it would be conditional. It would be unconditional.
There's no negligence on your part. There's no evidence. There's no evidence of negligence on your part.
Correct, and we don't need to show that AIM was negligent in order to trigger indemnity. It's just an arising out of the work. Because Mr. Devlin was their employee, it arose out of their work as a matter of law. So it's not conditional contractual indemnity, it's unconditional contractual indemnity. Further, to the extent that this court believes that there is no evidence that Stalco is negligent. Likewise, it should be unconditional. If this court finds that there are issues of fact as to Stalco's negligence, then this court could still find that Stalco is entitled to conditional indemnity.
What happens if there's a scenario where they're 100% responsible? It's 100% their negligence that causes it.
Well,
Wouldn't that knock out the conditional?
If Stalco's 100% negligent, then it would not be entitled to
we know that yet?
indemnity. I'm sorry?
Do we know that yet? Isn't there an argument, can an argument be made that they're 100% responsible?
I suppose it could be made. I don't think it has been, and there certainly haven't been found 100% negligent. Obviously, we concede that a negligent party cannot be indemnified for their own negligence. If it's 50% negligent, they can't be indemnified for that 50%.
But isn't this a case where we can't rule out that that's a possibility?
It's a possibility, yes. But if the court finds that they cannot be found negligent as a matter of law, it would be unconditional. If it's possible they would be found negligent, then I believe it could be unconditional.
Okay.
Thank you.
Thank you so much. Have a good, oh, you have 1 minute. I'm sorry, I forgot.
Thank you, Your Honor. I just want to say we agree with the court that the contractual exclusion should be dispositive here. And as to Mr. Calise's testimony, he also testified he never read the contract. Just want to make that clear.
Thank you.